Item 1502.
मुझे मालूम है बोलिए These appeals are at the instance of the state of West Bengal and arise out of two prior rounds of litigation wherein the state suffered judgments against itself. We have extensively extracted the relevant submissions made across the bar, and we have of the considered view that certain questions which arise for consideration, they are 13 in number, which we have, which we'll read. What is the scope and extent of the power under Article 309 of the Constitution of India? What is the scope and extent of the rules framed by the apparent state, that is ROPA rules, and the first memorandum dated 23rd of February 2009? Whether the notifications of official memoranda are issued subsequent to the clarificatory memoranda dated 23rd of February 2009, that is 9th of December 2009, 6th of April 2010, 23rd of October 2010, 12th of December 2011, 31st of December 2012, 16th of December 2013, 9th of January 2015, and 14th of December 2015, issued by the apparent state revising the rates of DA are in consonance with the ROPA rules. Given that the definition of existing emoluments in ROPA is identical to the central government rules, that is legislation by incorporation, could the state have then deviated from the index being adhered to by the central government? In other words, was the incorporation of AICPI number a one-time measure? Whether DA as a concept is static or dynamic, and whether by the act of the legislation recognition of a particular index does the character thereof change? Whether the actions of the apparent state are vitiated by manifest arbitrariness, as also negatively affecting the legitimate expectation accruing in favor of the employees. Whether adoption of the AICPI would render the distinct legislative domains under List 1, Entry 70, and List 2, Entry 41 OSHO. What is the impact of the direction of the tribunal for the state to follow the AICPI insofar as the financial autonomy of the state is concerned in the federal structure of the country? What is the effect of the findings returned by the High Court in its first round of litigation? Do the respondent employees have any right to receive DA twice a year in line with the pattern of the central government? Is financial capacity of the state a ground available to deny the payment of DA if under the existing rules the same is held to be a legal right? Since the question involved in this list is the payment of DA, which is an aspect of fiscal policy of the state, what is the extent of judicial review which is permissible? Can DA be said to be a fundamental right under Article 21 of the Constitution of India as held by the High Court? The claim of the respondents is for a period 2008-2019. However, the legal redress of the alleged grievance was only initiated in 2016. Was the claim of the respondent affected by delay and latches as such able to be dismissed? Now, these are the questions which in our considered view, which arose for consideration before this court. And we have answered one by one. We just briefly, we understand this morning, and we also have to go to the court, but we'll tell you. We have said that Article 309, we have extensively discussed, and the principles enunciated are non-exhaustive. One. Questions number 2 and 3, we have come to the conclusion that in some it is hereby concluded that DA by its very nature is non-static, fluid, and subject to change. How that change is to be carried out is through the AICPI. The first memorandum is also the subsequent memoranda fall prey to the fatal flaw that they do not make reference to the AICPI, which is absolutely essential to the determination of the DA, which in turn is indispensable to the computation of the total amount of existing emoluments. As a necessary follow-up thereto, it would be observed that the incorporation of the AICPI cannot be termed as a one-time measure, and once DA was defined using it, to take a different path would be impermissible in law. So questions 2, 3, 4 are answered accordingly. Now, insofar as question 5 is concerned, it has got two facets as we read. One is with regard to the arbitrariness on the part of the state, and the second is with the legitimate expectation of the employees. And all these, on both these issues, we have said that keeping with the judgments referred to above, the principle of manifest arbitrariness under Article 14 refers to legislation that is capricious, irrational, lacking reason principle, or excessive and disproportionate. Such arbitrariness vitiates both subordinate and plenary legislation alike. In the present fact, since the legislative exercise did incorporate AICPI into the framework, deviation therefore from without any basis or discussed above falls in the lacking of reason principle, prong to manifest arbitrariness, passed from legislative competence. For the apparent state to have deviated from the recognized position to something else without laying groundwork, therefore compromises the exercise of rendering it capricious. So that is what we have read. Insofar as manifest arbitrariness is concerned, we have further elaborated, and we have held that it is not so in view of Hakamchand Supra, which you had referred to. And insofar as legitimate expectation is concerned, we have said that, of course, it cannot be unless it is by rule of law. And we are of the view of that in the light of the principles referred to above, the legitimate expectation on the part of the respondents did arise in view of the change in the position of law. Otherwise, there is no legitimate expectation. Enactment of ROPA and its recognition of AICPI as the determining factor for the computation of DA. Now, questions number 6 and 7, whether there is any conflict in between the list 1 and list 2 of the schedule. We are of the view that this question does not arise in our considered view at all. And therefore, we have said that there is no conflict. These both are coextensive and working in the totally different plane. So, and the next question we have said is that the alleged conflict in our considered view is a figment of the imagination of the apparent state. The argument seems to have been conjured up in thin air. Where is the exercise of the power of the union, legislative, and executive imposing any conditions of the apparent state? On the contrary, the power exercised is only by the apparent state through the governor, permissible under the constitutional scheme in terms of Article 309 of the Constitution of India. Now, coming to the effect of the finding of the first round of litigation, we have said that yes, it has conferred a right on the employees. Twice a year. Here we are in agreement with the submissions made by the appellants that DA cannot be given twice a year. So that to this appeals are allowed. Now, fiscal policy and judicial review. We have elaborately discussed that once there's a right which is conferred upon a person, then fiscal policy cannot be come in the way of the disbursement of such rights. Now, whether dearness allows the fundamental right. We have said that in terms of the impugned, because it was not given up really, in terms of the impugned judgment, the High Court held the payment of DA was a facet of Article 21 of the Constitution of India. Before this court, however, the opposing parties have jointly agreed that none will press this question either way. That being the accepted position, we do not give any finding thereupon and leave the question open to be decided in an appropriate case. So the appeal is allowed to that extent also. Now, whether there is delay in latches, we are of the view that the employees have been relentlessly pursuing the matter before different fora. So therefore, their legitimate claim, which is recurring in nature, we're giving a fresh cause of action every moment, cannot be said to have been delayed, cannot be denied on account of delay in latches. Now, the directions part we have read is this. Apropos to the above, we pass the following order. The appeals are partly allowed on two issues. To receive dearness allowance, page 128. To receive dearness allowance is a legally enforceable act that has accrued in favor of the respondent employees of the state of West Bengal. Given its incorporation in ROPA rules, the AICPI is the standard to be followed by the appellant state of West Bengal for determining of existing emoluments. The employees of the appellant state shall be entitled to receive the arrears in accordance with this judgment for them from the 2008 till 2019. On 16th of May, we had passed following interim order. We have extracted that interim order where we had said that some amount be immediately dispersed. The interim directions issued are herein shall be complied with immediately. On account of subsequent change in law, if any amount that would be dispersed in compliance with the judgment shall not be liable to be recovered. Considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, a former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam Bhaduri, also a judge of retired judge of Chhattisgarh, and along with them, the Comptroller and Auditor General of India, or a senior-most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the release of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the appellant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Great. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना? No.
grateful.
Thank you,
Very.
But for you, we wouldn't have been able to, and my lord's contribution. Largely.
Your lordships have burned the midnight oil, but we have only worked around 10 p.m. or 11. Your lordships.
No, you have also burned midnight.
You don't know how much my lord
effort
had to,
we appreciate Mulas. We know.
Grateful. Very good. Very
Thank you.
good.
Thank you.
Item 1501.
For the reasons recorded herein above, we are of the considered view that the impugned judgment is reasoned and borne out from the material on record, except to the limited extent expressly modified therein. This court does not find any ground to take a different view from that taken by the High Court. Accordingly, the civil appeals are dismissed.
Thank you.
Item 1.
Lord, before your lordship begins the bench, Lord. Lord, that British motor case, that 104 is wrong. They said, yesterday lordship adjourned it to 17.
We realize that it has to.
Lordship may direct the registry to,
We'll do that. I think the order needs to be corrected.
yes, because it has gone to 17 because lordship is sitting in the combination.
Order needs to be. Today it is listed, na?
104 it is this.
Ma'am, just wait. Just can you wait?
I am in your lordship then. I just
no,
want
we'll
to
do that.
get your lordship notice.
We'll do that. What we are saying is that the item come.
Yes, yes, we'll do
You
that.
are here only.
Yes, yes, my lord.
You are one of those
It is a pleasure.
who never leaves the campus of the Supreme Court. just
It is a pleasure, my lord.
your affidavit have you filed?
Yes, my lord.
Affidavit.
Item second of February, my lord.
Malords, we are,
Very short affidavit I have
we
filed.
give, Malords, we undertake to Malords, provide the requisite undertaking before the jail superintendent.
But,
In terms of the affidavit.
But I fail to understand why a 32 and why a writ petition.
No, Malords, because there are multiple FIRs.
It's okay,
in
you have been
different cases.
granted bail in number of cases.
Malords, otherwise, Malords.
Otherwise, this will become a trend that file a 32 petition and get bail.
Malords, in this matter, Malords, because I would have been required because of the medical condition.
No, you
for the
recently,
emergency.
I was going through this order 212024. You have been granted bail in one case.
That's right, Your Lordship. But in this case,
No,
Malords,
so
I
why
would
to
have been-
bypass that remedy? Then it will become a trend. Everybody will file a writ petition, get a bail, and then if that petition is dismissed, come to this court
Malords, we went in 226 only for this reason.
for bail.
Pardon?
For bail.
Malords, we went, Malords, only for this reason that at 4 different cases, I would have been required.
How many FIRs are there against you?
Malords, total Malords cases in which Malords I am in custody, total FIRs are 21, in which 9 I have been acquitted. 12 are the pending cases.
And in 12, how many cases you have?
8 bails I have already got.
So how many are left?
Only Malords 4 matters.
4.
I
So
am
you
in
can,
custody.
if the court has granted you bail in 8 cases, 4 again the court will grant you if there's no material.
Malords, I will be required to, Malords, go to Chittorgarh, Malords, Bali, Jaipur, and Malords, one more place.
The interim bail is for how long? For what period?
Malords, we are requesting a lordship for 3 months.
3 months medical treatment for 3 months.
Malords, because I am the only Malords parent available.
One. According to you, what is that you said?
Lord, if a lordship will have this affidavit dated 2nd of February, Lord. 2nd of February,
Yes.
very short affidavit on behalf
No,
of the state.
where you have said that he will furnish the details of the hospital where his wife will undergo treatment surgery.
Age
Uh,
3 months.
So what is the period which you have suggested here?
Period, any reasonable period, whatever you have said. On period, Lord, I have not said anything.
Maximum surgery will take how much time?
My lords, surgery will not, my lords, it's a post-surgery, my lords, recovery will take, my lords, about 2 months.
No, what we'll do is we'll give you 4 weeks time for this. And should there be, depending upon the further requirement, then you move an appropriate.
My lords may have it for 45 days, my lords, for the reason that I am the only parent, my lords. My parents are not alive, my wife's parents are not alive. There is nobody in the family.
We have perused the affidavit filed by the
45
state.
days.
We have perused the affidavit filed by the state. In principle, state has no objection to the grant of interim bail.
It'll be on medical and humanitarian.
In principle,
Yes, ma'am.
for the reason that petitioner's wife has to undergo surgery,
And there is an 11-year-old child, you know.
and there is none else in the family of the petitioner to attend to her. More so when there is a 11-year-old child born through the wedlock. In these attending facts and circumstances, we allow the application in the following terms. A, the terms and the conditions set out by the terms and the conditions as the state has referred to in para 5 of the affidavit shall be strictly adhered to. The interim bail, the period for interim bail shall be for 45 days from the date of release. The petitioner, during this, we clarify that the protection is granted, that the liberty is granted only for the purposes of the treatment of treatment of the petitioner's wife, who has to undergo surgery on account of her personal ailment. Then, after the expiry of 45 days from the date of release, the petitioner shall immediately surrender.
And my lords, the conditions be subject to the satisfaction of the jail superintendent.
The petition shall be, no, petition shall produce with the concerned magistrate.
Consent magistrate.
Magistrate
On.
for
Then my lords, it will require court deferment. That's why my lords, I was jail superintendent earlier also, my lords.
Lord, he can file the undertaking for this honorable court to fulfill these conditions, my lord.
no conditions of the jail superintendent.
I am going to comply with all the conditions and I will
That-
give my undertaking in terms of the conditions given in
Jail
here.
superintendent, and petitioner shall file an undertaking before this court to the effect that he shall comply with the terms and conditions part of the order.
As a lord.
Very good.
Please, sir. Item number 2, I appear for the petitioner. Lords, in this matter, service is complete on the whole respondent, but as per the office report, no one has entered appearance. Lords, in this matter, I was non-suited on the ground that under the Chhattisgarh Commodification Act, my husband doesn't count as a spouse under the definition of member of the family. So the case against me is that I have created a subtenancy in favor of my husband. But husband is a protected member, my lords. He's the spouse under the definition of member of the family. And on the second count of bona fide requirement, the plaintiff already has 2 other shops in Mahalakshmi Market in the same area. And one shop he has already sought evictment against.
Subletting, you may be right, because the definition of 2B includes spouse.
Yes.
But as far as the bona fide requirement is concerned, you see.
It's his choice.
Milos, but I have a certain protection under the Act from evictment.
You take time to, okay. How much
You are
time?
there for the last 21 years.
Please,
It's
Milord.
not your property.
Please, Milos.
Please leave it.
Milos, then in
Please
that
vacate it.
6
No, no.
months' time may be granted, I'll evict, I'll
Six.
All
close my
right.
business.
Fair enough.
Undertaking.
Please. Grateful, thank you.
Item 3.
Your good name, please?
Advocate Namrita Chandorkar.
Namrita.
Yes, sir.
We are from my state.
Yes,
My
sir.
undivided state.
Yes, sir.
The lot belongs to the entire country, my lord.
No, but see, all fingers are not equal.
No.
Bias towards.
1 minute. Now, my lord now has to give relief to him.
Why is it Madhya?
Unfortunately, my lords, the stage of granting relief today will not come because the state is taking some time to come back with a bit.
No.
So,
Let us see first.
They filed an affidavit.
very good. So my learned friend just told us that, my lords,
There was
they are withdrawing their affidavit.
No.
That's fine, very
Didn't
good.
say that, I'm not
Very well.
going.
Better for us.
Your lordship had asked certain queries on the last date, your lordship, and I had given affidavit in this regard.
Maybe I'm taking time.
So the number which has come up, your lordship would have page 3, paragraph 4, where I have just given the list of the query which was raised on that day.
This is which one? Which affidavit?
3-2. We have filed
3-2.
Third February.
yes
Yes.
affidavit on the this is in the 1359 SLP Civil 1359 of 2023.
There are how many vacancies?
Yes, your lordship. Now, if your lordship would have paragraph 6, that the total vacancy of 7129 posts and the category wise detail was given in paragraph 7. Paragraph 6. Then in paragraph 7, it is stated that there was total vacancy of 3546 posts of home guard and the category wise detail is as follows. Then in paragraph 8, it is said that out of the vacancy of 3546, the total vacancy seat filled for all category of home guard is 297. Total women seat filled with home guard is 6. Total women seat unfilled for home guard is 116.
Such a hardly 300 people.
Yes. These are the seats, but your lordship, here what the case before you, your lordship, is that they are not having requisite qualification.
No, I was not able to find anywhere. This statement of yours is not in the main judgment. The issue was filling up of the vacancies which could not be which were not filled because of want of home guard candidates
Yes.
to be given to them. That was the issue.
Your lordship, the finding also says that the minimum requisite mark, the cutoff mark was 169.
No.
I'll show that.
That's
The
enough.
cutoff marks was 169. The marks of
Please show it from the
Please,
judgment.
your lordship. What judgment comes?
I could not find that line.
Absolutely right. The question is
Counter
about
data.
minimum eligibility, which all of us
No,
clear.
your lordship.
No, it's cut off.
As
Will
per
bear
the
with us.
advertisement
Now, my lords,
that-
now that my learned friend is going ahead, allow me to address it. Now, my lords, what had happened was this, and the infirmity in the order.
May I just
My
complete,
lords,
your lordship?
no, I am addressing the court.
We followed your cutoff issue.
Okay. Lords, insofar as the minimum eligibility is concerned, every candidate which is before the Supreme Court has minimum eligibility. Those people who do not have, I'm giving it as a caveat, those people who do not have minimum eligibility are not entitled to come in. I'm not claiming for them, first of all. That's the fair submission that I'm making. Second thing is this, that the High Court has messed up, lords, by confusing the cutoff with the minimum eligibility. Now, cutoff, my lords, is a dynamic concept. If there are 50 seats only, there are 500 people, the top 50 candidates, the lordships are. Now, my lords, therefore it keeps moving. There were more vacancies. So if the vacancies are increased, the cutoff is bound to fall, point number 1. The vacancies in this case exist. The rules say that if there are vacancies in the home guards and in the women reservation, they will have to be filled up in that year.
That is the law. That is what the rules are saying.
No, that is not.
Their own counter affidavit, I'll just one.
Yes.
Only, no.
So the.
He's right. Only in respect of women, the carry forward
Yes.
process will be applied.
Okay.
Your Lordship.
Only for women.
Now,
I just complete your Lordship.
therefore, when it comes, your Lordship's right.
Horizontal one.
That is, so therefore, because of the application of the law laid down by this honorable court, and we are carrying all of those.
How many candidates are there?
Well, it's
About
320 or something.
Here-
The vacancies are all there.
Can I just
And there is a
will
stay
find
on
one submission,
future.
your
There
Lordship.
is a, my learned friend will just bear with me. There is a future stay of future recruitment also by this honorable court. All of us can be adjusted this.
This 2025 recruitment.
Please follow us.
May I just complete?
I'm grateful.
My submission, your Lordship.
2024.
Can I start thereafter?
2024.
2024.
The Lordship would have by
Has been
counter
stayed by
in SLP
That's why I
3950.
request my learned friend to just hold his horses for 2 minutes, my lords. I'll just place the facts and after that he can have the consequence. My lords, that process has been stayed. There are vacancies arising from the 2015 advertisement under which we are claiming. This is the affidavit pertaining to that. The last order passed by this honorable court requiring the state to come forward and to give details was only under the advertisement of 2015. So what my learned friend has pointed out in paragraph 7 are the number of vacancies which are available under that advertisement, and they are now being adjusted here. We are candidates who, my lords, have promptly gone to court, have been agitating this by a wrong interpretation of the rules, and from their own counter affidavit, the rules filed by them, we can, my lords, make an attempt to satisfy your lordships, my lords, that the rule position is very clear. Home guard vacancies which are unfilled have to be filled up, number one. Number two, insofar as the women reservation is concerned, the law by this honorable court is very clear. They will not be followed, carried forward. You have to adjust them on this. So we carrying all of that. So, my lords, today, my lords, once they have shown that there are so many vacancies, without going into anything, my lords, all of us can be adjusted, and I am only asking for our adjustment.
They're your young,
May I just say, your Lordship?
they're young boys from
Your
the
Lordship,
state. Most of them have become
If
over.
I may,
Yeah.
if I may be just permitted to make two submissions, your Lordship. The first thing, your Lordship, as I have, I'm asked by the
Your Lordship, if I may-
council for the
Selection.
selection commission, your Lordship. Out of these vacancies, your Lordship, there are several which have been already filled by the operation of the advertisement of that year only itself, your Lordship. So, your Lordship, their data also need to be incorporated into
Then
this.
why you give this affidavit?
When I said, my lords, what's the affidavit, my learned friend just
Then
told
why
me
you
now.
have given this?
After argument, he's coming with this now, my lords.
Your Lordship, and the second thing, your Lordship, is,
Yes.
your Lordship would have my counter affidavit, which is in the Mahatabal case, 3950.
It is not within the news.
File a fresh affidavit.
Okay,
My
Lord.
lords,
But
but
your
you
Lordship,
be unfair of my learned
let's
friend.
have a.
Initially, he told me that he is taking time because he wants to change the affidavit. Now, my lords, seeing
He,
he feel the wind
might
have blown.
he might be under the impression that the second
Yes.
judge is there. So let me take a chance.
No, your Lordship. Lordship,
I couldn't have said it with greater clarity, my lords, that is all.
No, but see.
The cat is out of the bag.
They have passed preliminary examination. They have passed written examination.
Yes.
They have cleared the interview. They are physically fit.
Document verification.
Fit.
Yes.
Document verification. You do have vacancies. You do have large number of vacancies. And most of them by now are over.
Correct. That's correct.
If I may only. say-
No. Either you argue, we
she's-
decided. If you want time to file a better affidavit.
Okay, we'll file it,
No, there's only one thing I wanted to point out.
No, sir.
May I just,
1 minute.
yes. Your lordships are not passing in the office today, I know.
1 minute, 1 minute. On the last hearing, precisely what has fallen from a law, we have said that is why we asked for this information. So you better file a better.
I'll do that, your Lordship.
Simple as that.
I'll do that.
And let it be a win-win situation for all.
Okay.
That's all, the courtesy.
Only thing we have to see is just the seniority between them and them. That's about all. That will
That my lords can decide. That's okay.
Lord, I'm not part of this, but Lord, I have made an application for it. There is a reason for it.
We-
We are home guards. Our non-selection is under challenge. Your lordship's court, my lord, has issued notice in our
let us.
Lord, any filling of the post under the directions in this matter.
They have not passed their
Our
means.
legislation.
They haven't passed it.
Therefore, I wanted to bring that.
1 minute.
How many home guards are there?
Lord, we are in our petition about 200 home guards.
So vacancies are 2,000. 2,000.
There is scope for everyone.
2,000.
It's pending in court number.
1 minute. You want us to send it there?
No, I
problem.
don't say that.
Then
We are home guards.
we are saying we'll make a win-win situation for everyone.
Very well, Lord.
Please make sure that you're also accommodated without a judgment from that court. When we are saying that, Don't worry.
But this Vande Bharat Express has got too many coaches. Everybody can be found.
दिखेगा.
One clarification must come on record.
Thank you.
I'm really requesting.
Thank you.
You can only file an
You have
affidavit.
to mention before Honorable the CJ for listing of any man.
No, I'm not mentioning anything, Lordship. I'm on party here, Lordship. In this,
That's all right, then we'll consider.
I'm only saying, Lordship, that the affidavit is with respect to only vacancies, not that the horizontal reservation cannot be filled up. That's the
Seeks permission to
The
withdraw.
affidavit should be confined to vacancy.
Withdraw the present affidavit dated so and so. Present affidavit so and so. Affidavit dated so and so, filed on behalf of so and so, with the further liberty to file a fresh affidavit
3 weeks, Your Lordship. 3 weeks, Your Lordship.
containing
Notes.
better particulars within a period of 1 week.
My lords, I have not even till now heard what those purported better particulars are. My learned friend says better affidavit, but what better affidavit he wants to say is not something that any one of us are aware of.
Better affidavit within 1 week, list on dash.
1 week, Your Lordship, will be difficult, Your Lordship. 3 weeks, Your Lordship. 2 weeks.
Data is with them, Manoj, we've gone through everything, they filed an affidavit, at best a correction.
Thank you.
We can say. I'm grateful to your Lordship and also to Justice Sharma for putting to my learned friend what I couldn't have said to him. So, that's very good. Deeply obliged.
You were there in that Bihar matter?
Applause. Yes, Lord. That's
So you know the trend.
We've been here enough to see that. So, very grateful, Lord. Deeply
Grateful, my lord. Much obliged.
Grateful.
May I please? So all the affidavits on record, my lords. Lordship's query whether the regulation is applicable, whether Praneet case is applicable, whether are we receiving any amount from UGC, my lords. Because the affidavit says, my lords, up to 2018 we received grants. Thereafter, no grants from UGC by the university. Only with regard to, my lords, women's development, only we have received funds, my lords.
But you have received funds.
No,
Yes.
and your affidavit, with due respect, is a mischievous affidavit. Where is the affidavit? Please give it to me. I'll point it out. It's a mischievous affidavit. हाँ बताता हूँ. Please come to your affidavit.
My lords.
Where you have said about that grant.
It's para 3.
पूरा फाइल दे दीजिए ना आपने.
No, this is not the affidavit. एक दूसरा affidavit file किया है. In petitioner affidavit. This is an application for an interior. कल रात में मैंने देखा था.
Filed on 24.
File on?
24/1.
I've seen it yesterday.
Para 3 minutes.
Come to Parath.
Answer.
So what you're saying in this?
It respectfully submitted that the petitioner is receiving salary grants from Government of Tamil Nadu. University Grants Commission is not offering any salary for the faculties appointed in the petition universities. UGC schemes 10, 11 and 12 plans are implemented and faculties are appointed in the plan period. At present, 12 plan, Women's Studies Center is alone receiving the grant. Till 2000.
What is this UGC scheme 10, 11 and 12 plans?
These are the plans
What is
for
that?
development of Melod's travel grant, conference, public grants, appointment of visiting facilities, daycare, adventure sports. That's a heading, Melod's, for each and every.
That's a heading. I'll tell you what it is.
Melod's.
When a plan is sanctioned, 50 posts, 10 posts, 20 posts comes with the plan.
Please.
And in no university, once the plan is sanctioned by UGC, is discontinued.
Melod's.
So this you are receiving grant for number of teachers under the 10th plan, 11th plan and 12th plan. So just to misguide us, you have simply written UGC schemes are implemented. You have not said that you are receiving financial assistance for paying salary to the teachers under these plans.
No.
So that is why I said it's a mischievous affidavit. You are 100% receiving grant for large number of teachers from the UGC and for Women's Studies Center where teachers are employed.
Melod's.
No.
Distances.
I'm so grateful.
Grateful.
I filed an ID in the matter.
We are not impeding anyone.
Observation to that effect that we can, on the basis of order, we can.
We are not saying anything, ma'am.
So grateful.
Grateful.
Manoj, I'm requesting for a pass over and I'm 5.
Pass over.
What? That's okay.
Please, my lords. Lord, this is that matter your lordship said twice sent for mediation, my lords, between the husband and wife.
Waiting for a past.
Okay. Pass.
Please, my lords.
My lord, only last night I have received the counter affidavit, and I need to file the.
Let's see what the matter is.
It is about the additional charge, my lord.
Ah,
And certain deposition has been filed in the counter affidavit, and there are so many contradiction in that, and I need to file.
additional charge, see, counter we'll ignore. But additional charge, section 333 allows, so what is there in it?
No, that is, my lord, after
What is
presenting the
additional charge?
final argument,
Huh?
after presenting the final argument by both the parties.
Your 482 has not been allowed.
Yes,
Thank
the
you.
police inspector with the deceased.
Yeah, correct.
Has been assaulted.
Yes, yes.
Please, my lords.
My lords, I didn't understand.
Dismiss.
My lords, no. My lords, I have a substantial.
Then argue now. Yeah, that's what we.
Kindly pass over the matter. I will bring my file and I will argue the matter.
No problem. No problem.
Sure.
Come immediately because.
But my lord, the problem is that they have filed particular deposition.
Ignore that.
Sure.
You argue your case, please.
We are making it clear, come immediately, bench is available only for a limited period. Huh?
My lords.
Item 7.
And if you don't come by 12 o'clock, we are.
Dismissed.
Dismissed.
Lords, the state was the counter, my lords.
Which case?
Item 7.
No, settlement was there.
Said, my lords, we've filed the SLP, praying that there should be a appointment from this court.
Had we not requested for just 1 minute? No, sorry. Yes, argue.
My lords, the state had to file counter, my lords, it's not on record.
My lords, I appear for the state. My lords, it's a concurrent conviction. My lords may hear the matter and call for the records. There is a long list of evidence that has not been filed with the SLP, my lords. My lords, it's a matter of conviction under 420, my lords. There are over 5,000 members who were made to pay.
1 minute. Now conviction is there and suppose if you were to pay the money back.
My lords, is 420. So with my lord's permission, it can be. But we'll have to trace the complainants and all the members, my lord.
Lordships refer it to the mediation, my lords. The president will file an affidavit in the association.
You have taken money and you have not given plots. Give their money back.
My lords, I was 22 years, my lords, at that age. 2001 was the date of FIR. I was 22 years, my lords. Today I have come, my lords, only out of all 60,000 members, only 105 complainants are there. Even they have filed civil suits, they are in their respective position. They need something, I am ready to pay. So, my lord,
you're not doing charity. You have to return their money.
My lords, we'll do that. That is the petition. That is why I have filed.
Otherwise, go to jail.
I have filed the petition for that.
No, but will you pay? That's the point.
My lords, I left it to the court, my lords, that somebody should be appointed so that they can put their claims there.
Do one thing. What is the total amount involved?
My lords, they are about 105.
Total amount involved.
My lords, they have to put forth their claim, my lords. We cannot.
They are only asking you what is the money involved which you have taken from them.
It's the amounts.
You deposit in this court.
The president would be the best person to say, my lords, the association's president. We'll do that, my lords. The association president, my lords, if it's referred to mediation, he will come and file appropriate act.
These suits have been filed for what amount is what we are asking.
Suits they have filed for injunction, my lords. It's an injunction suit, my lords. It's at page 24, my lords.
You do one thing, we just pass it over. You ask your clients how much money he will be ready and willing. You see, we are conscious of the fact they have been convicted by the trial court, convicted by the first separate court, and then again convicted by the High Court.
Yes.
And 2 years is what the High Court has imprisonment. But what is the query put is, should you wish to settle, to test your bona fide, deposit money in this court. What is that money which you will deposit here is what we are asking before we even ask them.
May I submit, my lords? I also have surplus land. If title deeds of the land can also be deposited. Surplus land is there, money.
First,
I'll
you
just
go
find.
out and
I'll do.
how much of money
I'll.
and how much of land
I'll.
you are ready to.
I'll.
My lords, as per the charge sheet and even the facts recorded in the trial court, my lords, for the year, because this is almost a 30-year-old incident, and the transactions were in 93 to 95, my lords. My lords, at that time, the charge sheet records an amount of 5,35,000 only, my lords. So, however, my lords, this is as per what is on record, but my learned friend may clarify that. And it's also keeping in mind 30 years have gone by since.
Exactly. See, so 30 years, what would be the rate today is what he has to deposit. Simple.
Yes, my lords.
Go out and immediately just.
If we back matter and.
Grateful, ma'am.
And of course, this will be subject to the other side agreeing. We really don't know whether they want to pursue.
I will.
But suits are pending, they'll all come to an end.
Please, Sir. Just 2811, the Honorable Court made an interim order, a speaking interim order. I request to have a look at my Lord's order of 2811. Para 3 thereof is a request to consider. If I could place it for Your Lordship's kind consideration. Honorable Court said, inviting attention to the prayer clause C of the plaintiff, page so and so, it is argued that the amendment sought to be brought in, as is evident from the application page so and so, para so and so, was not for the purpose of changing the nature or character of the suit. It was very clarificatory in nature.
Let's see page 71 and 287.
Yes, perhaps. Because please have a look at page 84, my lords, want to see, my lords?
Yes.
84, lordship, have a look at. This is a part of the plaintiff, my lords, the prayer C, 84.
83.
Yes, I'll read from 83. My lord. 84 is the prayer C, but I'll read 83 also.
Anyway, it's all right. That the plaintiff is entitled to get possession of the land.
Yes.
And
the prayer is made, my lords, actually made.
Correct.
Now, my lords, then kindly see the application 266. The application is 294, I'm sorry. Where I sought amendment, 294.
What is the amendment? Page 294 that the plaintiff.
Yes, at 295, bottom of 295, just at the top, second line, the plaintiffs are entitled to obtain possession by partition of suits. So only clarificatory in nature. Prayer was already in the suit, my lords. The first appellate court holds in my favor in entirety, but on this ground, kindly see 266, because of which I made the application. 266 is judgment of the first appellate court. 266 para 31 is the request to consider. The appellant plaintiff also, I am for the plaintiff, has a share in the disputed land along with defendant so and so, but he has not asked for any assistance in partition in the claim. Therefore, this court cannot give any assistance to the appellant in getting possession of the land as per his right and share.
What is that the High Court?
But the court says kindly see at 267, 33, on the basis of the above findings, the appeal is partial, the first appellate court. The appeal is partially accepted and the judgment of decree of so and so is set aside. Following decree is ordered that the order of so and so is illegal, set aside, not binding on the appellant, etc. So no order for possession. So, you know, the High Court in this application.
High Court says it will change the nature.
Yes. That's the only, my lords.
My lords, allow me 2 minutes time and to show you 3 documents. It is my humble submission that they are arguing a settled position. Their amendment application does not clarify. It seeks to change the nature of the suit.
How?
Yes. Three documents. First, my lords, let's look at their amendment application, page number 294, 295. Page number 294, paragraph number 5, the third last line. My lords, by way of amendment, they want to now argue at the High Court stage that fourth last line from the bottom, my lords, page number 294, that the suit property is ancestral property
in which both daughters and the son of deceased Sukya each have 1/3 share. So their first amendment is that this property is not self-acquired, it is ancestral. Just on this point, there are the concurrent findings of both the trial court, the first court and the second court. There are concurrent findings. My lords may kindly have page number 149 just on this point. My lords may kindly have 149 of their petition. My lords, page number 149. I'm reading from the last two lines of page number 148, my lords. This fact is admitted by the plaintiffs themselves in their cross-examination. Not only this, Mishri Bai, my lords, she was a plaintiff there, she's a petitioner here. Mishri Bai herself has admitted in her cross-examination statement that the disputed land is not the acquired agricultural land of Sukya. That is a father. It is also admitted that the suit property has been purchased by Sukya from his hard-earned money. Her father was a hard-working person. In this situation, it is very clear that Mishri Bai has admitted the fact in a cross-examination.
We must correct you on one point. Are we to look into the evidence which has been laid for considering the application? 1 minute. All that we have to see is the plaint and the application where it changes nature and character. Now kindly come to his plaint, page 78, paragraph 2. Here he says, the heirs of Sukya, father of Kallu, includes son so and so. The Amrit died on so and so, before so and so, older Sukya, due to which the heirs of deceased are not defendant so and so. So all that he's praying is that the Sukya's property be partitioned. That's all.
Very well, my lord.
Therefore, he has set up it's not a new.
My lords, on page number 78 itself, the title of the suit was Declaration, Possession and Entry Name in the Revenue Records. The valuation of the suit was as per declaration. It was not for partition. In Madhya Pradesh, my lords, may just allow me 2 minutes.
Are we to look into all this at this point in time, whether the suit is undervalued or not? All that we have to see.
My lords, there are two important things that they did not argue for 18 years. The first is partition. There are two sisters. How are we to know? My lords, they have simply, by a simpliciter way, said 1/3 share, please include it in our amendment application. Now, my lords, the High Court at this stage cannot go into evidence to see how much share belongs to who. There are two sisters. That is something the trial court has to do.
And so therefore, the High Court will, all that the High Court has considered, or for that matter, we have to consider whether the application is belated, is necessitated.
But my lord, how can the High Court at the second appeal stage see what is the share of every person in this case? For that, a partition suit has to be filed. 1/3 share is something that they're claiming here in the Supreme Court and in the amendment application before the High Court 18 years after the trial has already begun. Lord's judgment, if I may just cite my lord, my lord's judgment of 2024, my lords, Dinesh Goyal versus Suman Agarwal. It is my lord's judgment in which my lord has. My lords may kindly see paragraph 11 of my lord's judgment.
Judgment is of the court, not my lord.
My lords, the same bench. Now, my lords, in this case, my lords had very well looked into what is the rule and the settled proposition on amendment, right? And my lords had also cited, my lords, the earlier case, which is Life Insurance Corporation. Now, if the facts of the case are completely changed, in this case, acquired property versus ancestral property, and 1/3 share. These are two specific allegations, my lord, that requires evidence to be laid.
We again put it to you.
Ji.
Whether the amendment is to be allowed, whether it can be allowed at the stage of second appeal or not, is all that we have to examine. Whether it nature changes, is there any bar that the amendment cannot be allowed at any stage of the? No.
My lords, my only request was, this is the Article 136 SLP that they have filed, and there is no reason, no substantive right that is extinguished. The High Court is still going to look into the merits. My lords, let the High Court decide on the merits. If they still have a grievance, their remedies are not exhausted. So why indulge them for procedure at this stage, my lord? That is my only humble submission.
So whether the further evidence is required or not is for the High Court to consider.
But my lords, the High Court cannot be asked to look into, and which is why the High Court rejected it. My lords, we just have page number 3 and petition, my lord.
I'm counsel to the party, we have to consider you. That the.
My lord, just one last line, my lord. My lords may kindly look at one line of the High Court order, page number 3. Page number 3 of the petition. My lords, the first paragraph, last line. The High Court says specifically, my lords, that the proposed amendment would
change the nature and that.
For partition and separate possession. So I am saying this requires dismissal at the threshold. That is my humble submission, my lord.
Would you allow us to know?
Yes, very well, very well. My apologies.
Chamberlain. Allowed him to raise the.
Please, Your Lordship. You must object, Your Lordship. I'm grateful to Your Lordships. Please.
Yes, my lords. I beg to appear on behalf of the learned ESG, my lords. We filed our rejoinder subsequent to the last order. My lords may post it for arguments any day.
Sorry, say that again.
My lords, I beg to appear on behalf of the learned ESG. Pursuant to your last election, we filed our rejoinder. My lords may post it for arguments on any day.
No, what is there to argue?
My lords, counsel for respondent is appearing to VC.
Please, my lords, I'm there on VC. For some reason, the video is not switching on.
That's okay. We can hear.
Lords, there are serious charges of corruption and sexual harassment in this case. The respondent has been awarded the penalty of compulsory retirement. Soon after, on submission of his pension papers, the pension was reduced to 2/3 of the pension amount by the competent authority, which is the Lieutenant Governor in this case. The competent authority continues to be the same. It's a part of his responsibility and a statutory penalty which has been imposed pursuant to Rule 40.
The Rule 40, does it say that the gratuity in pension is to be forfeited?
It allows reduction. It specifically allows reduction of gratuity and pension in cases where compulsory retirement has been penalty.
My lords, once the disciplinary authority has passed the order.
You were not called
Yes, my
upon.
lords.
You were not called upon. Please.
Which rule says that in case of compulsory retirement, pension and gratuity will be forfeited?
Will be subject to reduction, my lords.
Which rule says it will be forfeited?
Rule 40, my lords.
Where is that?
It's, my lords, it's extracted at page 3 of the impugned order. My lords may allow me to read it. Compulsory retirement pension. A government servant compulsory retirement from service as a penalty may be granted by authority competent to impose such penalty, which is the Lieutenant Governor in this case. Pension or gratuity or both at a rate of not less than 2/3 and not more than full compensation pension or gratuity or both admissible to him on the date of his compulsory retirement.
So that order should contain all this. Kindly read further. From the above, it is.
From the above, it is abundantly clear that reduction in pension or gratuity as contemplated under the said rules is not an automatic consequence of the necessity of compulsory retirement. My lords, this is our argument.
No. There has to be an order. You have.
My lord, that order was this matter. Once the Pay and Accounts Department considered the pension papers, it was reverted back to the Lieutenant General, who, upon consideration.
No, he can't pass orders in pieces.
My lords, once the charges have been established.
It should have been part of the main order only. That keeping in your misconduct, the gravity of charges against you, the competent authority is now reducing your pension all in view of Rule 40.
I quite see that, my lords.
Then the High Court has rightly dismissed it.
There is, my lords, it's our humble submission that seems to be a bit of a technical ground. In that, my lords, once the charge.
Unfortunately, people succeed on technical grounds.
I quite see that, my lords, but once the charges have been established, my lords, what's the nature of the charges? Sexual harassment, corruption.
You could have very well dismissed him for this.
My lords, dismissal was granted, compulsory retirement was granted.
It's not dismissal.
Compulsory retirement, my lords.
Compulsory retirement is not dismissal, madam. You could have dismissed him from service.
What my lord is saying is that if the charges were so serious and severe, in your wisdom, rather than allowing him to step out, you should have thrown him out, which you did not do so. So therefore, as an afterthought, today you cannot say that the gratuity in pension is also to go. Thank you very much. You argued very well. What's your good name?
My lords, Harshita Chaubey.
We appreciate the efforts, the submissions made. While fully appreciating the submissions made.
Yeah, Harshita was fighting with great force.
We find ourselves unable to be persuaded in allowing the presentation.
Grateful, my lord.
Grateful, my lords.
Item 10.
Executive for the petitioner units, as per the office report, the respondents have been served.
No, sorry.
As per the office report, the respondents have been
What about the office report? We often say that we issue notice for various reasons.
Well, this was a matter, where I have filed a fresh suit. But prior to that, I moved an application under Order 23 Rule 23 Rule 1 for withdrawing my counterclaim. Pursuant to that, I filed a fresh suit seeking my share in the property. That was rejected by the learned trial court under Order 7.
Kindly come to page 43 and
Any liberty was granted to you.
With all due respect, lords, the order says in terms of the application. Please have an exhibit P3 at page 43 for a while, lords.
Your application is, where is your application?
My application is at
101.
Lords. This application was filed by, this is under Order 7 to 11. Lords, we just have the initial application filed by me for withdrawing the counterclaim.
Where is that?
Madam, please come to page 40 in exhibit P2.
40.
The operative part is at page 42. If Lords permit, may I read?
For while reserving the right to represent the case if a new dispute arises.
Now, please come to page 44, what the learned trial court records. So this is a dispute between the brother and sister. Page 44, if my lords have that. The operative part, I read, on the basis of the application regarding the counterclaim, the application under Order 23 Rule 1 is accepted and accordingly dismissed. Therefore, it was on the basis of the application. In the application, I specifically stated, I reserved my liberty.
No, just one. Let's read the page 43 together. The case record was perused. From the examination of the case record, it is clear that after submitting the application, defendant Mullabai did not produce any evidence. From the application submitted on behalf of the defendant Mullabai, it is clear that she did not wish to withdraw her counterclaim due to any procedural defect that may cause its failure, but rather because she does not wish to seek any relief from the plaintiff.
Is a plaintiff. For the reason why I said so, my lords, may just have my application for a while.
We have seen.
The application says that since because there could not be any in future, if any, since the parties were living with each other, both the brother and wife, the brother and the sister, and in order to maintain harmony between the parties.
The only difficulty which is coming this way is these 4 lines at page 44, top 4 lines. That's the only thing. Because it doesn't say simply that the application is disposed of in terms of the application is allowed in terms of the prayers made in the application.
Well, the learned trial court, with all respect, records on the basis of the application. So if I say on the basis of the application, that includes whatever I have stated in the application.
You are the...
I am the sister. I am the sister. And Jhansiram is my brother. My share in the property is 0.49 hectares.
0.49
hectares.
Long pending dispute, small area involved.
Therefore, I was under the impression that the respondent would have been appearing in this matter would have been sent for mediation, but he chose not to appear.
Then what do we do? Thank you very much. Thank you. You're not replying.
Lords, that was all respect, Lords. The application was rejected only when it was.
Either not right.
Object.
May I please, Your Lordships? Lordships, I've been led by learned senior Rahul Kaushik, sir, but
This is infructuous already.
before my learned friend will say with regard to the infructuousness, let me at least put forth what the issue is, that Lordships.
Let her say.
Lordships, the present SLP is as against the challenge of the order under 227, Your Lordships. The High Court, on 3 occasions which I had presented that this RLTOP is not maintainable, was not considered. As against that only I have come over here, Your Lordships, before the Supreme Court.
You're a tenant.
Your Lordships, I am not a tenant is what the dispute is. Therefore, I had filed a suit, which is a proceeding, wherein issues have been freed and P1 has not come into record.
Suit claiming that you are owner by way of adverse possession.
I bow down, Your Lordships. Lordships, over here. Lordships, but that suit is pending. My humble submission is, Lordships, may I say this?
There's a person who's claiming adverse possession. There's a person who's holding clear title.
No, Your Lordships, that is what. They are not holding title. My submission is not even a single document. Your Lordship may take the rent control proceeding petition. It says that for arrears of rent. But whereas over here, Your Lordships, if assuming they should have filed it, it should be on only 21(2)(a). Your Lordship, last occasion we had circulated the act also, Your Lordships, for your kind perusal. Only under 21(2)(a) they ought to have filed. Rather than 21(2)(b), they cannot file. Your Lordships, may I say this, Your Lordships?
You simply withdraw it, saying that the
appeal is pending.
Your Lordships, appeal is pending, Your Lordships, but as far as this issue is concerned, even RLTOP cannot decide on the title, Your Lordships. Lordships, on title it cannot be decided is what my humble submission.
Is this ground in appeal?
Lordship, we have raised it that.
Raise it, then please argue it.
Because the reason under 42 it is barred to look into that issue, Your Lordship. For a moment, for the provision alone, Your Lordships.
Your decibel level just low.
Your Lordships, I'm sorry. Lordships, 42 provision alone, because
you are a tenant.
Lordships, I'm disputing with that, Your Lordships.
But courts have held it so.
No, Your Lordships. May I say this? The agreement, not even an agreement, one receipt with the brother of the tenant as holding.
That you have filed a suit for declaration.
Yes, Your Lordships.
Of title on account of adverse possession speaks volumes about your conduct.
Lordship, may I say this then, Your Lordship? Let me have this. Let me contest the suit, Your Lordship, because my.
Please, we are not touching the suit. The suit is not subject matter of this.
It's not a subject.
Please.
Lordships, but with regard to the title, Your Lordships.
No, very sorry.
You want to withdraw or dismiss?
Lordships, let me just.
You have filed an appeal and please raise all grounds in that.
Lordship, they cannot decide that issue is what my humble submission.
The court will pass it on that ground.
Well, fine, Your Lordship. Only to that limited extent, Your Lordship passes, because otherwise they will not entertain RLTOP or that is continuity appeal.
Please challenge that order. Next case, please.
Item 12. Lordship, let me withdraw it, Your Lordship.
It's permission to withdraw. Simple.
Item 12.
Yes.
Please, Lords. Lords, it is a dispute between legal heirs of brothers and sisters.
Who are you?
I'm Milord's wife and legal heir of Shivalinga, whose favor 2 sisters.
What is your claim which you have set up?
Milord's, my claim is I'm in adverse and ouster possession since 1980.
Can a co-owner be an adverse, take plea of adverse possession?
Milord's, in my favor in 1980, delinquent rights were transferred in my favor.
Then you can't be in adverse possession. Either you're owner. See, you're either co-owner or you're an absolute owner by virtue of your own right, but you can't take such destructive.
That is a lot more details.
Lords, during the life, Lords, one submission.
All 3 courts have decided against you.
Item 13.
I appear in 13.1 for accused number 4.
My lords, this is a case under section 302. What has happened, my lords, in this case?
You filed an application for.
This is an SLP against conviction, my lords.
Yes.
It's coming up for the first time. I'll just give my lords a very brief introduction to the case and the key
Is there
point.
no eyewitness to it?
My lords, there is an eyewitness as per them who has a motive to implicate me. But be that as it may, the defense witness who we led, my lords, is admittedly the first person to inform the police about the offense. The police comes to the spot at his instance. They record his statement. He truthfully says that the deceased had a knife in his hand. There was a quarrel, and in that process, the deceased is assaulted. The eyewitness, so-called eyewitness, my lords, his statement is recorded more than 2 hours after DW1.
There are two, please kindly see, there are two eyewitnesses. Okay, let us discredit the complainant. PW5 and PW1 are there.
My lords,
The eyewitness who,
PW1 is the complainant. And so if we are to discard PW1, my lords, we are left with PW5.
Correct.
Now, even for PW5, my lords, his statement is recorded much after the defense witness. Secondly, my lords,
impeach the credit of this witness then.
my lords, he also,
Can you see what you have cross-examined him on?
my lords, he also,
His presence is not in dispute. Having witnessed the occurrence of the incident is not.
my lords, but he has also lied about the fact that the deceased was also holding a knife. My lords will have to compare the versions of DW1 and PW5. They are both
DW1.
My lord,
Where is DW1?
DW1 has been annexed at page 267. Annexure 12. The IO admits, my lord, that he is the person who called at 1:20 a.m. and his 161 was recorded. My lords, these two witnesses will have to be compared in terms of whose credibility is more. Further, my lords, in my learned senior's case would be different, but in my case, there is the additional fact that my name is not in the FIR anywhere.
You are for accused?
Connected matter, accused number 4.
Number 4.
Sachin.
What do you have to say?
Yes. My lord, the entire evidence, my lord, in this case, my lord, has to be appreciated considering the fact it's a case of gang war. The two rival gangs, my lord, have clashed. As far as PW1 is concerned, my lord, he is already an accused, not only PW1, but the deceased himself was already an accused in respect of a case of attempt of murder of accused number 1. And they were released on bail just a month or so prior to the incident. Then your lordship will finally see, my lord, it's a case of having 3 eyewitnesses. DW1 was supposed to be examined as a prosecution witness. He was not examined as a prosecution witness. That's the reason we examined him as a DW1. Lord, he is a manager of the concerned bar who knows all the persons, my lord, the accused as well as, my lord, the witness on the deceased, because they were frequent customers in his bar. They used to come to consume liquor frequently. But he categorically says that PW1 and PW5 were not present at the incident, at the spot of incident. Then there are several other aspects. Your lordship will kindly see that as far as PW1 is concerned, my lord, when he says that though he was accompanying, my lord, the deceased, when the incident occurred, he had crossed the road.
Where is your 330?
Yes, 313. In additional, no?
My lord, my 313 is at page number.
No. Yeah, PW4. He has a better case than you.
Yes.
My lords, we have the identical case.
No, you are the person who is.
My lords, if my lord is going to believe the eyewitness, we
we have to believe what is there in black and white. With due respect.
My lords,
Because they are not in front of us.
My lord,
in front of us, this black and white is there.
DW.
So we have to lie.
If I would,
with due respect.
I would respectfully submit, my lords, DW1 is also present at the spot.
Doesn't mean if 10 people are present on spot and the police, only 2 witnesses have been examined, it doesn't mean that testimony of those 2 has to be ignored. It doesn't mean that.
My lord, certainly not. But then DW1's...
Even 1 witness is good enough.
But my lords, DW1's testimony should also not be ignored, and my lords will have to go into that and compare the 2 versions. My lords, this is a witness who is the first person to call the
Then
police.
who has killed him?
My lords, DW.
All right, all 5 of you have not killed him. Then who has killed him?
My lords, in fact, PW1's own.
He has stabbed himself.
My lords, if I may respect.
What is this you're talking?
PW1's own testimony is that this is a man with a large number of cases against.
He'll start stabbing himself.
And a large number of
What,
killings,
that,
my
that
lords.
is why I want to know who he will start stabbing himself,
My lords-
seeing enemies in front of him. It is just not possible.
My lords, the other people have more.
Other people have stated against you.
There is a 330.
That is not on record. I will file it.
No, we are not.
And my lord, I have the hard copy. I'll just read it.
Just show it. Just
Yes, yes.
You want to see the defense you have taken?
Yes, yes. The defense is that.
My lords, other defense that I have taken is that none of the witness originally named me.
We have seen your ma'am page 265, your defense.
He says he was not there.
My lords, if I may just clarify, they say that I am a bit two. The person.
क्या हो गया? नहीं बोलते. अच्छा.
See, the moment you take that I was not present, I was at a particular place, the onus and the burden shifts on you.
My lord, I have led.
1 minute, ma'am, please.
Yes, yes.
You know.
That's true, my lord.
So what is the evidence you have led to establish this?
My lords, if I may respect.
No, please.
Questions for me.
Sir has to respond.
Yes, yes. My lord, that's right, your lordship. My lord, there is no evidence to that effect. But your lordship will kindly see himself. My lord, I am just assailing the evidence of PW1 and PW5.
Thank you, sir.
PW1 and PW.
My lord, may please wait a moment. My lord, may hear the other. My lord, my name is not in the FIR.
Thank you, ma'am.
My lord, may just consider this. They are saying that a certain bit to.
We've heard you now.
My lord, may I simply request? I'm requesting, my lord.
We have seen all the testimonies, ma'am. We're telling you.
My lord, may I make one request? My lord, may keep this matter tomorrow. Give me two. My lord, may consider this one argument. My lords, please. I am not named.
My lord, item 6.12, my lord. अच्छा, oh, my lord.
Item 13, I think my argument is not yet complete, Your Lordship.
Okay, no, no
Yes.
problem.
Yes, I'm grateful.
What is?
Go.
See, we put it to you
Yes.
that you have taken a plea of alibi.
Correct.
Now, if you have taken a plea of alibi, then you know the law.
Yes.
It is for you to establish that.
Yes, my lord. Now, my argument is that even if, my lord, there is no evidence, my lord, corresponding to the defense taken, my lord, under 313, under section 165 of the Evidence Act, my lord, a duty is cast upon the concerned court.
Correct.
Yes. And, my lord, that issue has been considered by this honorable court.
We have, just 1 minute.
Yes.
For a moment, there is no doubt that you are innocent and the prosecution has to establish the case beyond reasonable doubt.
Correct.
We have not, I mean, on that proposition, you need not cite any law.
Yes.
What we are saying is that evaluation of the testimonies of 3 witnesses, DW1, PW1 and PW5, when we compare, we find the testimony of PW1 and 5 to be more convincing, satisfying.
Yes.
More so in view of the fact that it has been correctly appreciated by the courts below. And we do not find any perversity in that. That is one limb of the argument.
Yes.
The second limb of the argument is that now you have taken a plea of alibi.
Yes.
Were you not obliged to independently establish that alibi? Because unlike her, you have not maintained silence. She has maintained silence. You said that no, I was at X place. Now, if you were at X place, you didn't say that I was not there. Your categorical statement is that I was at X place. If that is so, then under the Evidence Act, to establish that fact would be on whom is what we are asking ourselves.
Yes. Now, my lord, for a while, my lord, this plea of alibi, my lord, kindly ignore it for a while. Now, I am on the point of credibility of the evidence of PW1 and PW5, the so-called eyewitnesses, as against B. And it's not only as against, my lord, the petitioner who is accused number 4, but also against accused number 5, though I am not appearing for him. Because the PW1, my lord, in his evidence says that initially the attack was carried out by accused number 1, 2, 3. He says A4 and A5 came later on and joined them. So there also, my lord, this is very vital.
For what?
My lord, I came later and then assaulted. Obviously, my lord, he obviously says assaulted. So now the point is that as my argument, I started my argument with the case that, my lord, it's a case of gang war. And, my lord, evidence, my lord, will have to be very carefully examined. Considering this angle, my lord, there will be every possibility, my lord, to involve the other person from the other gang or the other group. That's the reason, my lord, the evidence of DW is very vital. As I said, my lord, he is a manager, my lord, working in the bar. He was well acquainted with all the accused as well as, my lord, the deceased as well as, my lord.
Yeah, we have applied our mind and sorry, sir.
So, my lord, as far as, my lord, my client is concerned, my lord, there is enough evidence. My lord, even accepting the excluding this plea of alibi.
Thank you, sir.
My lord, may I apologize. Just may I say 2 things, my
Yeah,
lord. I will
certainly.
not repeat. Give me 2 moments, my lord.
We will just, do you wear a watch?
I do, my lord.
Uninterrupted, your iPad would be having open. Uninterrupted 5 minutes given to you. Please, proceed.
I am most grateful, my lords. I am not going to repeat 2 things, my lords. Firstly, the 2 eyewitnesses that my lords are convinced by PW1 and PW5. They say, my lords, they name a person called Bittu. They do not take my name. My name is Suraj Singh. My lords, it is not put to me in my charge that my name is Bittu. It is not put to me in 313 that my name is Bittu. Not a single other witness, my lord, says that Suraj Singh was also known as Bittu. For the first time in court, my lords, the witness says that he is also known as Bittu. whether in fact, my lords, I was actually present at the offence, given the belated manner in which my name is coming up, my lords, is something that my lords would have to consider.
We have considered. What is your cross-examination on this issue?
My lords, both PW1 and the IO, I have cross-examined saying that I was not known as Bittu. I have cross-examined the IO saying nobody told the IO that my name was Bittu. My lords, imagine the witness says a Bittu was also present. He does not give my address. He does not give any indicator to the fact that I am Bittu, and he claims to know me right from the beginning. He doesn't even say Bittu was the pet name of the person. I have cross-examined PW1 and the IO on this point in great detail. And my lords, it is not put in my charge or in my 313 that my name is also Bittu. My lords, they have done nothing to say that the person initially named.
Point well taken. Don't repeat. You
Certainly.
were there.
My lords, the second point, my lords had said that even if one was to discard PW1 because he has enmity, my lords, this is a point where PW5, the eyewitness, and DW2 would have to be compared. The normal parameters of seeing whether an eyewitness is credible, my lords. Did he promptly inform the police? And has he told the whole story? Now, my lords, on promptly informing the police, DW1 is better because he is the person who calls the police and says, come here, a fight has taken place, the deceased is lying dead. Has he told the whole truth? PW5, my lords, lies and says that the deceased did not have a knife with him. It is only on cross-examination and confronting him with the other documents that he is forced to admit that the deceased had a knife with him. On the other hand, the defense witness, right from the beginning, is saying the deceased had a knife. He was having a quarrel. They assaulted him. He tried to assault. They were more in number. They assaulted him and they ran away. PW5, my lords, is friends with PW1 and the deceased who have enmity with my group. DW1, on the other hand, is a neutral witness who knows everybody equally.
What does DW1 say?
My lords, he says that he knows all these people. The deceased was at the bar. He stepped out. Some other group came, not us. They were quarreling with the deceased and they assaulted the deceased.
Thank you.
My lords, my only request is give us an opportunity to read the evidence and compare it, my lords.
Thank you, ma'am. Thank you.
Only one, I'm sorry, my lord, because two lawyers are, I just missed one point.
Two lawyers, we have independently.
No, my lord, I just, my lord, I want to highlight one mandatory provision. My lord, under section 157 of CRPC, whenever any FIR is registered, Lord, it is mandatory that it should be, my lord, informed or sent to the concerned magistrate within 24 hours. This is very important, and admittedly, my lord, this has been done. That's the reason I say that.
A short adjournment, and then arguing counsel is out of.
You have to argue, please.
But it's the arguing counsel is
have only been handed
not
to the
in
brief this
city.
morning. So if they have asked for an adjournment, they have apprised me yesterday that they're seeking adjournment.
They didn't mention to the court.
They didn't mention it to me, Manoj. That is why.
They didn't mention to the court. Yes, please.
No, the arguing counsel is out of city. I have no idea about this.
I'm just gonna have it tomorrow, Manoj. Tomorrow.
Okay.
Very good.
Grateful.
Very good.
And he's grateful for asking.
Counsel, we'll pass over a file. You be ready. We'll give a file to you. You should have mentioned to the bench yesterday.
Morning, I heard them from the arguing.
Don't feel him. Call tomorrow in the morning.
May I please, your lordships? My lords, I'm appearing on behalf of Gram Panchayat. My twofold arguments are this, my lords. We were not in the cultivations prior to January 1950. This is what the Holdings Act clearly says, my lords. The second argument is this, my lord, that there is a judicial order, page number 31, my lords. 30th of March 1967. Please see, my lords. In this order, they themselves have moved an objection that the earlier land which was to them were not fit for cultivation. Therefore, another piece of land was given to them. So, my lords, in my humble submission is this, that by piece of evidence that
Yes.
but they have to establish by way of evidence that they were in possession prior to 1950, 26 January 19, which they have not established. This is what electors have observed in this order. This is what commissioners have also observed in this.
This is exactly what they.
High Court have ignored, my lord, this page 31. Please see page 31, my lords.
31.
May I read it, my lords? The second paragraph. After hearing the petitioner thoroughly, I have gone through the record, and that the only objection of the petitioner is with regard to the area of his tenancy under the Gram Panchayat. He says that the area given to him now in rectangle number 10, etc. is unfit for cultivation. He should be given some other area for the Gram Panchayat, which can be given to him. Therefore, in order
What
to
is the extent of area?
my lord,
Brief canal. इतने छोटे लोग
they can be declared as owner, my lord. They were
no, they are not they are praying for any charity. They have established their right.
Please, your lordship. This is item 16.
Yes. Yes.
My lord, this is a motor vehicle accident case. This is a death case wherein your lordship had recalled the order, wherein the SLP was dismissed.
This was in which combination?
Before your lordship and Justice Koteshwar Singh.
लिस्ट इसको करिएगा मैम कोटेश्वर साहब के साथ हम कब बैठे शाम को लंच कम आफ्टर लंच कम आफ्टर लंच
मेरा भी बहुत म्यूजिकल चेयर टाइप का
तो हमारे तो लंच आफ्टर लंच आएगा आइटम 1
Very good.
Item 17.
My lord, in item number 17, my lord, yesterday I received the typed copy of one annexure, my lord, filed by the respondent. Now, my lord, I need to check the veracity of this annexure from a department because they say that there is one group O. On instruction, I say there is no group O. This CGA policy was only for group C and D. No group O exists, my lord, in our department.
Lord, maybe in the typed copy it's come as O, but otherwise it's D only. Maybe the type.
only.
My lords, it's D. And this document was a part of the High Court record also, my lords. And they never raised any objection to that. This was placed in the High Court.
Today may not be ready, perhaps.
Well, it's no, my lord, please keep it on.
List on, as per the respondent list on coded books.
Deeply obliged. There may be an error in the typed copy. It is.
There's no group O.
Deeply obliged.
My lord, this the High Court has considered the income on the lower side. In this, my lord.
So what about the service?
Service is complete, my lord. I was appointed as a mitre.
No, did you write to them?
Yes, my lord.
Where is your affidavit that you've written?
On the last day, the respondent to company appeared. They filed a counter affidavit also.
Who's for Manjeet Chawla?
Well, we have filed the counter affidavit as well.
What do you say?
My lords, in this regard, my lords, they have not filed their any income. My lords, if my lords may have the paper book, my lords, may kindly see one that they have not adduced any evidence at trial regarding their income. MECT list of documents is on page 60. Lords, may have page 60. Not even a single whisper of how much he earned, not even his bank account statement.
What is your income? You were serving abroad, no?
Yes, my lord, but
Where is the evidence that something, not evidence, but even something to show that what is that you have?
Unless there's a visa, if I may interrupt. Unless there's a visa on page number.
No, visa doesn't help him, huh? What was he doing there? How was he? What was he employed as? And what was any statement on record is what we are saying. Forget about documentary evidence.
my lord, we have produced the
Where is that?
ID card in which in company which he was working.
Where is that?
It is in page number
मैंने ये record आया है क्या?
33.
MSCT पर. What was the basis on which the High Court determined your income?
My lord, it was literally totally on the unskilled worker. He was considered as an unskilled and he was given the order. And
unskilled worker.
my lord,
ज़्यादा मिलता होगा उसमें.
my lord, lady 28 years.
That doesn't matter.
He was working in which country?
Dubai, my lord. Dubai.
ज़्यादा मिलता होगा.
In 2015, what would have been his notional income there?
Well, they have not produced any application under Order 41 Rule 27 for the High Court that they have moved regarding this income certificate.
One thing you with your friends, any document, any.
My lord, so illiterate, the lady who has her husband, she's illiterate, my lord, she can't travel to.
No. This person must be having some bank.
My lord,
Yes. And he must be sending some money to the lady also. So if he's sending 25,000 per month, it means his income is more than 25,000 per month. So you have to do some homework. He was in Dubai, she was in India. He must be sending a month money every month.
He was recently married, my lord.
Recently married, उसको अपने parents को भेजता होगा. My lord is giving you a clue. Why don't you take it?
Yes.
Find out on the family something.
Is it a referred brief? Oh, ये होगा ना.
यहाँ तो यही होगा. You are not from Telangana.
No, my lord, I am from Karnataka.
Karnataka.
What do you say, Michaels?
There's only one document on page 35 which only says that Subhash Manikappa was to be employed as a foreman in so and so company, but that is not signed or there's no stamp. There's also not on the official letterhead of the company.
So, but
yes, my lord.
Come to page D. Page D. From where the statement has come, the petitioner here is the wife of the deceased Subhash. Deceased Subhash was a supervisor, foreman stores in Dubai.
Yes, ma'am. My lord, his salary certificate is also from Dubai. She can't obtain it, my lord. The income certificate.
He suffered the accident before that, and certificate is pre-dated.
Established.
ये proof
तभी तो उनका official record है. इसको लिखते
अच्छा.
तो अभी 1 महीने में कर देते हैं.
So he must be sending money to his father.
My lord will try to produce the income. Okay.
The other thing is that you have to convert 8,000 rupees into a D.
Yes,
then would it make any difference? Just see it.
Yes, but he's aiming to be earning around 3423 AED for that.
No, we are saying something else. If money earned in India is
okay. All right, great.
Then
I'll come back.
Giving you a clue.
I'll kindly give us 3 weeks time, my lord.
Try to put the record में डालो, digital. Record of the MSCT, also the High Court. We called for a digital copy supplied to the Land Council within 3 days. In the meanwhile, we allow the petitioner to place on record any document indicating the income of the deceased from a predecessor interest of the present petitioners. That is I.
Item 19.
Hello.
And for the petitioner, your lord, this motor accident claims, my lord, a deceased. We are the legal heirs of the deceased person. Two grounds, my lord, I am pressing, my lord. First ground is that, my lord, he is a semi-skilled worker, rubber tapper, but his income was taken only as 10,000 rupees monthly income by the High Court.
What should it that be?
My lord,
What should that income be?
my lord, at least, my lord, 500. It is not even 500 rupees per day for a semi-skilled worker, my lord.
In 2015, what was the income of a skilled workman? What about semi-skilled?
My lord, 4,500 was for unskilled worker. It was in as per the Ramachandrappa case. In 2004, it was 4,500.
The High Court has taken 10,000.
Tribunal took it as 8,000. So when it comes to a semi-skilled worker, my lord,
10,000 is what we are saying.
yes, my lord. So when it comes to a semi-skilled worker, my lord, it must be much above than 10,000. This is my first argument, my lord.
Must be, can't be, must be. Yeah. Who's for the respondent?
No, so I'm for the insurance company.
What we can do is, Mr. Counsel for the insurer, we can give him a lump sum figure, increase by about chart के हिसाब से 730 741 हम अपने चार्ट से
May I submit my second ground, your lordship?
Yes. What is it?
That is, my lord, it was my appeal and there was no cross appeal or a counter from the respondent. Even then, my lord, in several heads, the High Court reduced, though High Court increased 1,27,000, High Court in several other grounds decreased 1 lakh rupees.
All right,
So
we'll increase something. We'll increase.
Interest of justice.
Obliged.
We have the considerable interest of the best met with the amount of compensation so determined by the courts below, further enhanced a lump sum of 50,000. Then the usual.
Obliged.
So I am appearing on behalf of the petitioner. I'll be seeking 2 weeks.
ये वो honorable justice के पास में 21. अच्छा. Okay.
I will be seeking 2 weeks time for filing a short rejoinder to the counter-affidavit filed by the respondent.
Lord's petitioner volunteered to pay a sum of rupees 10,000 per month to show his bona fides. However, not a paisa, not a single money has been taken.
You kindly appreciate my learned friend has entered her appearance only on 28th January. Price notice has been issued from the Honorable Court.
We have filed our counter affidavit on 28th January.
Very well, no problem. Rejoinder be positive filed within 1 week.
You also kindly grant 2 weeks time.
2 weeks. Problem 2 weeks. The amount of maintenance.
He is already married. He has breached all of his conduct.
Of maintenance as noted by the courts below, the areas of towards the maintenance be positively cleared before the next date. Good day. List.
Item 21.
Deeply obliged. Your Lordship, petitioner will have to pay maintenance.
दीजिए.
Your Lordship,
Your
Lordship, it's not true. I have not get any instruction that how she is saying, on what basis.
She's saying is maintenance, if any areas be
Should be
cleared,
paid.
that's what. ये वो फाइल में
Online first.
ठीक है.
Records भी आए ना.
पासवर्ड कर दीजिए.
Item 22.
21.
21.
After lunch.
Okay. After lunch.
Deeply obliged.
22.
Lordship, I'm requesting for a small adjournment.
22 में adjournment.
Yes, Lordship.
On her request adjourned. List on.
May I please the Lordships, my lords? The petition.
A bail.
My lords, so far as the impugned order, observation in the impugned order is concerned with regard to abscondence, my lords, I leave it to your lordships. With two submissions I would like to make, my lords. First, my lords, though in the FIR a case of illegal trafficking has been made out, but no such provisions have been implicated in the charge sheet, my lords.
You're Mansoor, na? Your name.
But my lords, one last submission, my lords.
You want anticipatory bill after anyway?
That's
Funding.
I completely leave
No,
it to your lordships, my lords, on that point.
No, please. No, if you agree with me, then be happy.
That's why I'm here for the state on advance service.
Yes.
Your presence will be marked.
Lords, liberty may be given to move for regular.
Who's stopping you?
When will you surrender? Okay.
As your lordship says, my lords.
Undertakes to surrender on or before 1 हफ्ते का time दे दीजिएगा. Yes, sir. As and when the petitions, with the petitioner surrendering, it shall be open for him to move an application seeking bail, which shall be decided in accordance with law.
Obliged to lordships.
Undertaking accepted and taken on record of the year.
Obliged to lordships.
In 1 week surrender.
Item 23.
23.
23
ये तो हो गया.
23, I just appeared in this matter.
24.
24, I am appearing through VC, my lord, due to some bad throat.
Item 24, who's there?
I am appearing, my lord. In item 24, I am appearing.
We are issuing notice.
Lordship, please. Lordship, I kindly condone the delays, legal aid matter, my lord.
No problem. Delays control. मैम एक काम करिए. वो सरकारी वकील साहब की हाजिरी लगा लीजिए. Name to be reflected. Reply 2 weeks. Rejoin 1 week. और जो हमने कल ऑर्डर किया ना, एक रजिस्ट्रार साहब से रिपोर्ट मंगवाई है.
इसी में कर देना. इसमें भी कर देना.
इसमें भी कर देना.
Obliged, my lord.
Item 25.
Lords, in item 25, your lordships had asked me to prepare the report, my lords, of the amicus, handing it over because the portal would not accept it, my lords, as a filed document.
अभी मसीह साहब के साथ सुन.
हाँ ठीक. ये
सबर दो फिर.
ठीक.
Post lunch.
Sorry, post lunch. 2:15 बजे आदत हो गई है.
2 o'clock. That's because of High Court.
Because in the High Court it was 3:15.
Yeah, High Court.
Yeah. 2:15. Leave leverage.
26.
My lord, 26 page 81 shows that, my lord, the matter had been referred to mediation where it had been settled.
Mediation is paid now.
No, my lord, mediation had been conducted, my lord, page 81 may kindly be seen. It had been already referred to mediation and where the matter had been settled also. Kindly see page 81 of the paper book. 81, 82.
Disposed of in terms of the settlement.
Yes, my lord, yes.
No, you say you don't press in terms of the.
Lord, that this information has never been conveyed to me by the party or the
That's all
council.
right. It say does not press the present petition in view of the report of the learned mediator as forwarded with a communication dated 10/10/2019 that of the Director, Kerala State Mediation and Conciliation Center. That's it.
Grateful, my lord.
Item 27.
My handicap today, my lord, is that the High Court on the first day dismissed the petition, but order is not available. And my lord, for almost 2.5 years, or maybe 2 years and 3 months, there was status quo order operating in my favor. The builder, my lord, wants to extend his building, and for that, whatever shop, whatever halfway, my lord, was available, that also wants to be demolished.
Your own case is that you are not in possession.
No, my lord, that's not.
No, your own case is that they've demolished. You have put up a tin shed there now.
Which is existing. Please have a look at, my lord.
After your no.
Please have a look at, my lord, the order passed by the appeal court at the interim stage. Page 37.
It must have been uploaded by now on the website.
No. It is not. Lord, 2nd of March it was passed. And Lord, the High Court rules require that you have to issue rule, make it returnable, so that Lord, I can file my reply. Lord, whatever Lord may be reasons against me,
Notice, लिखिएगा, इस status को as
I'm sorry.
I think 28 co-accused have been already granted bail, my lords.
It has to be tagged.
Yeah, my lords, interim to me also, protection from arrest. This is an anticipatory bail.
Same order, वो दे दीजिए और tag कर दीजिए.
Others have been granted. Who will also?
Yes, sir. My lords, the others are coming on 9th February, my lords, after notice. So this may also be listed on 9th February.
You accept notice? Yes. वो कर दीजिएगा. So same order. With the same condition subject to joining in. Obviously.
Yes, yes. Great.
Passport file.
Please, Milords. Because here the wife moved an application, Milords, on the ground. In the divorce proceeding, Milords, the husband moved an application that injuncted the wife from coming near to me because I am carrying out a 70 crore project. And on that basis, Milords, the trial court says.
No, it is that you will not enter the matrimonial house.
Yes, Milords, look at the plea. Yes, Milords, the pleading. Yes, Milords. No, in every which way, Milords. Kindly see, Milords, what has been recorded.
We tried mediation, it didn't work.
Yes,
you know, you have a right to, residences on a matrimonial.
Yes, Milords, that's right, under the DV Act.
One minute.
Yes,
1 minute. But under what circumstances? What circumstances?
Milords, when I'm in the sharehold, living with the husband.
Better both of you sit and sort it out again. Mediation.
Milords, we have tried, Milords.
Tried multiple.
I'm ready to go back, Milords. He's not ready to accept.
They interacted with the parties, Milords. Thereafter, Mr. Basant also had tried.
Oh, Mr. Basant.
Also tried, Milords. We had made multiple attempts, Milords. The wife is adamant she wants to live with me, Milords. My move.
That you give up. That insistence that you want to live there only, give up. Or some alternate accommodation will be provided for you.
Let him provide alternate accommodation.
She's living in Banjara Hills with her parents.
We are only saying.
Banjara Hills.
And Milords, with her parents, Milords, since August 23, we have not lived together.
Maybe you are living in Banjara Hills.
Both of them, Milords, both of them come from a yes, Milords. Now, therefore, Milords, my only concern.
I also stayed there for 2 years. I think they're not known to me. No.
I didn't see that coming.
But Banjara Hills, she doesn't need any accommodation if she's having a.
Yes, Milords. Now, therefore.
Very well-known people live there.
That's in fact, she's not even moved a 125 application, Milords, despite multiple proceedings. So both of them are reasonably well off, Milords. That I think is an admitted fact, Milords. It's an interlocutory order, Milords. Let the divorce and the restitution petitions be disposed of in accordance with law, Milords. That's all my request is. Because your Lordship has noted the parents, I live with my parents, Milords. They have issues, Milords. There's an FIR charge sheet under 498 against my parents and my extended family. There's no possibility for us to live together, Milords. With greatest respect.
Mediation has failed.
Mediation multiple times, Milords. Before this honorable court, the mediator, the Supreme Court mediation center. Your Lordship has also interacted with the parties, Milords.
Milords, may have it after 2 weeks, Milords. I'll again speak.
Put it to her.
Yes.
Put all issues
to
an end on his circuit. But we are telling you what is going to be the outcome.
Please.
Obliged.
Passover 6.
Obliged.
Yes.
My lords, why the additional charge should not raise? There are two aspects of it, my lords. That is, first is that wrong charge has been framed. It is not due to hurt or assault, but it was because of the heart attack. And kindly see page 45, my lord. It is very specific.
We are not driving you to charge has been framed to be proven by the prosecution. That's about all.
But that is the initial charge, my lord. That is after the final hearing. 1 month has been passed and judgment, it was fixed for the final judgment. And
so therefore, if the court feels that charge was required to be framed.
Exactly. I'm not denying that, my lord. What I'm saying, kindly see 45, my lord. It will be all clear, my lord. Why it is not even there are two aspects, my lord. That is not a hurt also. Kindly see para 21. It is true that as per the histopathology report, PW 49, the disease was already suffering from heart disease and illness of the heart artery previously. It is true that the heart of the disease was excessively weak due to such defect, and there was every possibility that he may suffer the heart attack anytime.
So this
It is, my lord, just 22, my lord. It is true that disease Vikas Sharma was not died due to any assault or hurt, but it was due to heart attack. The witness stated on his own that it was due to excitement. When it was asked to the witness whether excitement can be caused without any dispute, then the witness stated that there are several reasons for excitement. I am saying that 333 is for grievous hurt, and there is no cause of hurt or assault that has been. And kindly see page, because this honorable court has granted the bail, and while granting the bail, 42, page number 42, my lord. However, para number 3, page number 42. However, taking into consideration the expert medical witness.
Thank you.
Murders.
Please, Manoj.
Murders, but he was not on duty also.
Thank you.
Not he was hurt also, not even he is on duty.
Thank you. Please, Manoj. Yes, have you taken him?
Wait, please. I have.
Much over it.
My lords, I have, my lords. My lords, as per the charge sheet, my lords, I have to repay about 30 lakhs, my lords. As per my account, it is coming to 33 or 34 lakhs.
30 in which year?
In 2001. So I spoke to my client, my lords. Then whatever lordships, whatever terms and conditions lordships
You
will,
tell us what you will deposit.
the interest from 2001 or whatever.
We do not know. What
Initially, we'll deposit that amount, my lords, and whatever the interest or anything
No, you
decided.
deposit, you do one thing, you deposit 2 crore rupees.
My lords,
And also your title deeds.
my lords,
Simple. And then we'll call them.
my lords. For 2 crores, my lords, I need 1 week to understand, my lords.
People.
Let the petitioner deposit. Council under instruction submits. The petitioner can deposit a sum of rupees 2 crores in the registry of this court. The amount be kept in fixed deposit or renewal more. Let needful be done within a period of how much time?
Well, they need about 4 months.
4 months.
Because 2 crores are not interest with interest. What
In installments, spread over a period of 3 months. The first installment to be paid within 3 installments. These are tranches. First to be paid within to be deposited within 2 weeks. Then also petitioner shall deposit the title deeds. The title deeds of which land? Land, which land?
Well, as the schemes as mentioned in the charge sheet.
Which title deeds of the
schemes mentioned in the charge sheet.
Of the area forming part of the scheme, subject matter of the FI.
Yes.
The title deed, the documents of title deed deposited in the registry within a period of 1 week from today.
My lords, maybe 15 days.
No problem. 2 weeks from today. ये लिख दीजिएगा. And council under instruction further submits that the land is unencumbered and is in possession of the petitioner. Correct?
My lords, it's in the possession of the parties. I cannot say it's already in their possession.
Unencumbered case. Unencumbered, has clear title and is unencumbered. Clear title in the petitioner's name. This Tom Dash. Now
the interim protection may continue.
Intend to continue to the next date.
Great. Great.
What we'll do is, can you do one thing? A different combination is there. You are here, Mr. Bar. 2 o'clock. Thank you.
My lord, may I mention 102, my lord?
Post lunch. Sorry, my apologies.
Has to be taken. Any past years, like,
थोड़ी देर के बाद लीजिए। एक वो ब्रिटिश मोटर वाला जो है वो हम तो डेट जिस दिन साहब के साथ बैठ रहे हैं करते ऐसा तो नहीं।
No, before your lordship starts his own mail, trouble your lordship for item
बोल दिए
104.
ब्रिटिश मोटर वाला आपके देखते ही बोल दिए ब्रिटिश मोटर वाला जिस दिन साहब के साथ बैठेंगे उस दिन लगा दें।
Lordship has said 17th.
17 को बैठ रहे हैं कि साहब के साथ You have merged into that company or
No, no, we have not merged. The banks have merged. It's a private merger.
करना पड़ेगा साथ को साथ लगाने के लिए।
कर दीजिए ना सर कर दें पार्ट
जैसे भी Lordship may have it at
up to you entirely.
सर आपके पास है
आपके पास नहीं whatever convenient. मैं तो हूँ।
Lordship may have it at 2 p.m. may not get over.
And we will have.
I'll leave it to your lordship. Convenience.
I think it, but it is covered against you.
Because that's what lordship every time tells me, but
scare you.
no, but because we have points to distinguish.
Okay, very good.
My lords had indicated.
The lordship is making 17th February. Deeply obliged, Lord.
My lords, you had indicated item 16. That's a motor vehicle accident case to be taken up before the special bench.
8 minutes.
The order was recalled. It was passed by a.
वो सैमसंग हम इसको रख लीजिएगा सबके साथ ही है हाँ
पार्टनर करके करना
पार्टनर नहीं करिएगा ना जिस दिन आप
वो ना बेंच का प्रॉब्लम होता है वो खाली वही मैटर लेते हैं जो पार्टनर है
कर दीजिए एक और है ये 21 वाला डेट बता देंगे ना इसमें तो हर रोज ही बैठ रहे हैं उस दिन एक करके ले लेंगे ये जो आइटम 21 है और जो 16 है तो एक करके ले
और 25 रह गया बस अपन
Chief, that amicus is also here, man. So the report has been asked to be placed on 25. Both of us are here.
It has to be allowed.
Because I'm in the middle because I didn't get space, my lords, on the other side.
No.
I just wanted to place one point, my lord, for your
We'll
lordship's
do it. What we'll do it now. Today we'll not take it up. Same combination is likely to be there on Monday also for some time. So then we'll take it that day.
This one point, my lords, I'll place for your lordships and I'll leave it to your lordships.
You're a Micus, no?
Yes, sir.
You've written to her.
Written. The entire report, my lords, is before your lordships.
But to our understanding, 90 that matter where 90,000 was paid or some.
9,30,000, 30,000.
Was left.
30,000.
It has to be allowed.
That's what my lords is saying, my lords. Just one point and I'll leave it after that.
What is the point?
My lords, on the issue of readiness and willingness, it has been held concurrently against them.
You know that.
By the first appellate court as well as before your
As
lords.
against the consideration of 9,30,000, if only 30,000 in the balance consideration.
Lords,
Then we say readiness and willingness.
Lords, the agreement gave them an option to pay within 4 months or to deposit it in court.
This time was the time the sense of the contract. Look into that.
I'll look into it.
We are indicating.
Yes, my lords, of course. We'll be there.
Monday, man.
My lords, in item 16, Samson D matter.
We have told you, sir, we'll take it up. We've told you. Some date will be there.
Obliged.
Start.
With my lord's permission, just before my learned senior staff, the lordships are appearing, we filed the final report in this matter. There's just one small request.
Which case?
The lordship's item number 301.
Charge sheet. Wait, what is the final report? Justice Committee?
Yes, yes.
This is it.
Independent committee
Justice
final report. In item number 301, the lordships, we have filed that. There is one small request from the committee that an honorarium may be fixed for the.
We are conscious of that.
Your lordship, it may be mentioned in the order that a specific fixed honorarium may be provided
We
to
are
engineers.
we are conscious of that fact. We are deliberately not touching that aspect. We are deliberately not touching that aspect. We'll do that.
Not this side, there are several councils.
So whichever way.
I have a special bench, Lord, so I'll just finish that and then.
No problem, we've told you that none
Lordship.
would be having,
I'm
none
grateful.
would have any grievance, they have not heard.
I'm grateful.
The, thoda kagaz de diyo. Yes, start please.
Lord, I appear, my lord.
देखो भी करेंगे. मैम Tuesday का क्या status है? Tuesday को किसके साथ हैं? आप किसके साथ हैं सर?
Yes, my lord. But I appear some of the allottees, my lord. And there is a miscellaneous application filed for cancellation, which I'll be referring to, my lord. And I'll give the number also. I've already given to the court master the files which I will be referring to. But before I do that, my lord, may I request your lordship to have the proceedings of this court in the writ petition. Starting with, my lord, the first order by which bail was granted to Satinder Bhasin. Now that is an order passed, my lord, on 6th of November 2019. So if you can hand over the proceedings of the court in writ petition criminal 242, which contains all the order sheets, proceedings of this court, the orders passed from time to time. And starting from 6th November 2019.
तो बोर्ड तो डिस्चार्ज कर दूँ? मैम बोर्ड डिस्चार्ज कर दीजिए.
Then what do we do? They don't have the order sheet.
Cancellation of bail application and have it available. We have to
consider proceeding for reading
There must be the most fundamental.
You want us to refer to the bail order?
That's 6th November is the bail order. And then there are other orders passed, my lord, in the said writ petition, which I want to refer to, my lord, pertaining to settlement issue, my lord. Because since I'm appearing for the allottees, my lord, I want to highlight that particular fact. But first, my lord, please have the order of 6th November. I believe, my lord, now your lordship have those orders, my lord, in this file. 6th November 2019 order, my lord. Just 2 paragraphs, my lord, and then the operative direction by which bail was granted. Your lordship has that 6th November order?
6th November?
6th November 2019. That's the order granting bail subject to certain conditions.
To some other orders in the set writ petition, which talk of settlement, etc.
Yes.
Lord, your lordship has that order, my lord, 6th November 2019.
By this order we propose.
That's correct, my lord, that's correct. Please turn to my lord, para 4. My lord, your lordship, Justice Singh also has that.
Yes, I will.
Correct, my lord. Just come to first para 4, my lord. There is a reference to large number of FIRs which have been lodged. Just have a look at that, my lord. There are several FIRs, I won't read that. Just make a note of that, my lord. The lordship sees that para 4, several FIRs. Now come to para 7, which refers to the allegation in these FIRs, my lord, filed by the unit holders or the allottees. It is also.
How many FIRs? 18 or 19?
190.
No, number of FIRs against him.
Against Satinder Bhasin, 190. 190. It has come on record, my lord. In the other matter,
Because para 4 reflects only about 90.
That's right. But there is another order which refers to some more FIRs.
190.
Yeah. Para 7, my lord. It is also noticed, your lordship has that. Para 7. It is also noticed from the allegations in all the separate FIRs filed before the concerned police stations. Same are virtually similar, if not identical or stereotyped, and essentially making grievance about non-delivery or possession of units to the concerned complainant allottees, including the assured lease rental assured returns in respect of the concerned units. The other common aspects in the separate FIRs is about non-completion of the project as assured and about siphoning of funds. Please make a note of that, my lord. About non-completion, non-allotment, not giving renters assured returns and siphoning of funds raised from the completion of the project in question. The common allegations is also about legality or impropriety in allotment of land to the company by the officials of UPSIDC. The latter allegations, however, is common only in the FIRs registered in the state of UP. Notably, the investigation of FIRs registered so has been entrusted to a special investigation team constituted by state of UP. To that extent, all the 37 FIRs registered are being investigated by one agency, and that agency is filed charge sheet. So I just wanted to show your lordship what are the nature of allegations in the FIR. Now your lordship may straight away come to the bail or the operative order in para 16, my lord. Para 16. May I read, my lord, para 16? In view of the above, we dispose of the prayers for interim relief in terms of prayer clause C and D of the writ petition on the following basis. The petitioner is granted bail in respect of all the FIRs registered in prayer clause C in respect of the project by name Grand Venice in NCR, in particular mall and commercial tower thereof, on the following conditions. Please mark that. I'm so sorry, my lord. My lord, Roman 1, please make a note. Petitioner shall not commit any offence of similar type of which he has been accused. And siphoning is one of that, the allegations in the FIR. Your lordship have seen that one. So shall not commit any offence of similar type. Then, my lord, if your lordship turns over to also, my lord, the petitioner shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to denude such person from disclosing such facts to any police station or tamper with the evidence. Because, my lord, there is something on this also. We'll point that out. Then, my lord, I'll just skip and come to Roman 6. Roman 6, my lord. The petitioner shall deposit an aggregate amount of 50 crores before the registry of this court as a precondition for grant of bail. On deposit, so petitioner shall deposit, my lord, on deposit of such amount, authenticate copy of the receipt issued by this court be produced before the concerned court investigating officer. The amount so deposited by the petitioner in the registry be invested in an appropriate account. Then, my lord, Roman 8 is very important from the allottee's point of view, my lord. Just have a look at that. After being released on bail, in terms of the order, petitioner shall make every possible attempt to settle. Because this was also highlighted by my friend that the condition was attempt to settle. And I made bona fide efforts to settle. That's the my lord, submission of my learned friend, my lord. To settle the claims of the concerned complainant informants as far as possible within 6 to 8 months. So within 6 to 8 months, the time period is also mentioned by the court, as ordered by the Court of Chief Judicial Magistrate while granting bail to the petitioner in FIR 38 registered with the economic offences wing. So that is one of the FIRs, my lord. Roman 9, if the petitioner fails to abide by any one of the above conditions intentionally, and if it is so established before this court, no less than 50% of the amount deposited by him in this court in terms of the order shall stand forfeited.
That will be in addition to cancellation.
So, my lord, this also, my lord, I believe, my lord, in one of the earlier hearings, Mr. Devan said the only consequence provided is 50% of the amount deposited shall be forfeited. My lord, I don't think that's a correct reading and a submission made by my learned friend. Assuming, my lord, we are able to establish siphoning or tampering with the evidence, then, my lord, Roman 9 can be read. If I'm not able to establish, a different matter, my lord. But if we are on this side able to establish that this has happened, then, my lord, to say that the consequence is limited to 50% of the 50 crores amount may not be correct reading of the order. This is in addition to cancellation. Now, my lord, let me take your lordships to another order of 8th August 2023. August order, my lord. My learned friend's client wanted a refund of that 50 crores. While rejecting that, my lord, 8th of August 2023. While rejecting that, my lord, request for refund of the 50 crores, which the court rejected outright. In fact, the court said, if you want the money back, surrender. That's what this court said, my lord. That's 8th of August 2023. Paras 11 and 12, my lord.
1 minute.
I'm so sorry. I know, my lord, there are large number of orders in this matter, my lord.
No difficulty.
Yeah.
Anything else?
In the same.
Sorry, senior.
Lord, 240, writ petition 242, my lord.
242.
Yes, my lord. 8th August 23 order.
Yeah.
My lord, your lordship will find para 11.
Just 1 minute, sir. Honorable Justice Oka.
Yes, my lord. Yes. That's correct.
8th of August.
Yes. Order sheets.
But not a separate one.
Order sheets they have not compiled with separate.
8 August.
My lord, perhaps I should have done it, my lord. It's my fault.
There's so many on non-relevant orders also.
I know, my lord, there are quite a few, my lord.
Really eligible.
8 August.
Huh?
Really eligible.
Do it, whatever you want. My lord, can we help your lordship by giving a soft copy or something?
My lord has it, but just.
But again, my soft copy of I'm able to get it. 8 August.
May I do this, my lord? May I just read?
8 August 2023.
8th August 2023. Then take out 2nd September and 24th January. 2nd September 2024 and 24th January 25.
Mr. Mehta.
Yes.
8th of August, then
8th of August 23. Then after that, I want to read 2nd of September 2024. Then I want to read 24th January 25. These are the orders I want to read.
and 1 minute. One more order whereby the writ petition was disposed of. Which is that order?
That's the 8th.
No, writ petition was disposed of, the consolidation order. That was on 12th of May 2020.
The writ petition was disposed of.
Not disposed of.
No, it's
writ petition is
pending application. No, it's not the 8th August 23. 8th August 23. The writ petition is also disposed of on the above terms. So, about 242 came to be disposed of by 8th August 23 order. Then subsequently applications came to be filed and the further orders are followed on the applications. And those orders will require, which I've just mentioned, 2nd September 24 and 24 January 24.
It is disposed on the aforesaid terms.
Yes, well, your lordship has that, Madam? Just give it to those orders, two orders, 2nd September 24 and then 24 January 25.
सॉफ्ट कॉपी में नहीं है आदमी देखना पड़ेगा
हमें देखिए
Eight August 2024.
23, sir. 8th August 23. Honorable Justice Oak is heading the bench.
With no soft copy is very.
No problem, sir. ये लीजिएगा. अच्छा. कॉपी है क्या? लीजिएगा.
Well, I apologize for this inconvenience, fellow. 8th August is available now. Lord, your lordship will find in the 8th August order by which writ petition is disposed of, a prayer was made for refund of money. In para 11, your lordship will find that. Para 11 of that order. Now the issue which survives for consideration about the prayer for refund. Now, my lord, the court cites, my lord, or extracts that part of the order, 6 November, then para 12. Thus, deposit of a sum of 50 crores was a condition for grant of bail. Therefore, it is obvious, after having availed the benefit of bail, now the petitioner cannot back out and say he may be permitted to withdraw a sum of 50 crores which was deposited by him as a condition for grant of bail. If the petitioner wants refund, he'll have to surrender the petitioner cannot have it both ways. So, my lord, just see, my lord, he first, my lord, as a condition of bail, say, I'll comply with the condition. Once, my lord, he gets bail, he now says that I will want to withdraw. Para 14, we reject the prayer made by the petitioner for a grant of refund of sum of 50 crores and interest thereon. My lord, the allottees wanted distribution of that amount, my lord. My lord, if your lordship sees, in these proceedings, we cannot decide the issue of distribution of any of the sum of 50 crores. The fourth respondent represents only 70 investors, and whether 17 members of the fourth respondent entitled to a refund is an issue which will require evidence. We are unable to accede to the request made by the learned senior counsel appearing for R4, but that amount be paid over to, not because the reason is obvious, my lord. My lord, the request was made because this was our money, which was used for deposit. Now see para 20, my lord, para 20, 20. Because we said, my lord, that the bail should be cancelled. So para 20, the court gives me this liberty to all the allottees. Your lordship has paid para 20, it will be open for R4 or any other party to apply for cancellation of bail granted to the petitioner under the order dated 6 November 19. If such an application is made, registry shall accept and place it before the appropriate bench. So that liberty was granted. Writ petition, my lord, para 22 is disposed of on the above terms. Para 22. Now, my lord, come to 2nd September order, my lord, 22nd September 2024.
Stick-ons दीजिए.
My lord, I'm sorry. 13th May 24, my lord. My mistake. 13th May 24 first, before we go to 2nd September. There's another order, 13th May 24.
नहीं दूसरा.
That's also important, my lord. 13th May 2024. May 24, you have given. Yes. The lordships have been able to locate the order, my lord. 13th May 2024. My lord Justice KAROL also has been able to locate it.
Kali, I'll be doing that. You may pursue, please.
My lord, this is important, my lord. Let's have a look at what the court says, my lord. We have perused the supplementary reply. We have perused the supplementary reply filed on behalf of the petitioner. We are not satisfied with the stand taken by the petitioner that he has made genuine effort to settle the dispute with all the investors. In fact, from the order of 6 November 19 granting bail, it is apparent, please make a note, it is apparent that the object of releasing the petitioner on bail was to facilitate settlement of the claims of the investors. This is the court saying, my lord, not we. That was the purpose, that you will go and settle with these investors. That's the object, which is recognized and acknowledged by the court. That you will go and settle, not make bona fide and sincere efforts. I'll come to the bona fide part later. Firstly, we will call upon the petitioner to file a detailed affidavit setting out the reasons why petitioner could not settle the claims of 41 investors named in the status report filed by the respondent 2 on 8th of May 24. We grant time till the end of June 2024 to the petitioner to do so. After looking at the details submitted by the petitioner, if we are satisfied, please note, if we are satisfied, all efforts have been made by the petitioner to settle the claims with these 41 investors. We will look into the claims of other persons as well. More than 4 years, my lord, please make a note. More than 4 years have elapsed from the date of grant of bail. So, my lord, the court is noticing the time period which has elapsed because 8 months was given. We are putting the petitioner to notice. If we find there is no genuine or bona fide effort made by the petitioner to settle the claim of even one investor, that may be a ground for cancellation of bail. Just see how strongly the court is putting it, my lord. So to say that the court only wanted me to make bona fide effort, is that correct? You were released so that you could settle with the investors. Please note, 2010-11, all these investors have paid 80 to 100%, my lord, of the installment money, my lord, to the builder, to the developer. 14, 15 years down the line, we have not seen, my lord, these units completed or and possession handed over. So, my lord, if we find that there is no genuine or bona fide effort made by the petitioner to settle the claim of even one investor, that might be a ground for cancellation. So, my lord, to say that bona fide and sincere effort, that's not what the court thinks, my lord. The court's understanding of its own order is very clear. That's the point I'm making, my lord. Come to 2nd September, my lord. 2nd September 2024.
And then
2nd September 2024.
Please read.
Yes, my lord. Now the issue is now the issue is whether original writ petitioner has set. Yeah. This is 2nd September.
Yes, please.
Now the issue is whether the original writ petitioner has settled the dispute with 103 investors. Not bona fide effort. Have you settled? For the time being, we are dealing with cases of 41 investors who are referred to in para 28 of the rejoinder filed by the petitioner to the response of the state dated 23rd August 24. We direct the petitioner to implead these 41 persons as party respondent, file an amended copy within a period of 1 week, issue notice, registry to forward the notices to the office of so and so. The 41 persons shall come.
What happened? Then what happened? After this?
That now I want to read one last order, my lord, 24th of January 25. Because, my lord, several orders have been passed from time to time. I'm only bringing to your lordship's notice, my lord, few of them. Please come to 24th January 25. So we have reached 25 now, my lord. And that order was passed in 2019. No settlement. 24th January 2025.
In your submissions, you don't say all this. You see the difficulty which.
My lord, I will show that, my lord, because perhaps your lordship saw the recent application.
Submissions.
I see, submissions.
See, the submissions, the purpose of submissions is only this, that we must know what is that you are going to
I apologize, my lord. I'm going by the record only, my lord.
Therefore, day before yesterday.
No, I know.
Yesterday we told you.
Lord, I understand.
In your submissions, there is nothing which is mentioned except for bold,
No, I appreciate, my lord. I appreciate. Lord, your lordship has the order now, my lord, 24th January 2025.
Yes.
We have perused the affidavit of compliance. He was asked to, my lord, file an affidavit of. I'm so sorry.
Please read.
We have perused the affidavit of compliance along with the tabular chart filed by the state. The tabular chart is only in respect of 43 investors. Chart shows still the petitioner has not settled with many. Time and again, this court has granted time to the petitioner with the hope that he will settle the claims of all the purchasers. Settle the claims, not effort. A perusal of the orders passed by this court from time to time will show only by way of indulgence. Please note, only by way of indulgence. This court has kept on postponing the consideration of prayer for cancellation of bail. The court has granted indulgence to him. Now it is not possible. Now it is not possible for the court to grant further time. If in one of the orders we made it very clear, unless the claim of every investor is settled, petitioner cannot continue to avail of the facility of bail.
Then what happened after this?
Lord, after that, my lord, the adjournments, my lord, because the court did not have time, my lord, and there is no substantial order till such time, my lord, your lordship took up the matter, my lord's order of November. My lord, your lordships have seen this. Third paragraph is, however, by way of indulgence, you have to file an affidavit, you have settled. So, my lord, then your lordship's last order of, sorry, what is that?
This was in January 25.
January 25 is another order, my lord. Where is January 25? No, I'm also having.
That's what you read out.
No, I read out 24th January.
Yes.
Correct. Your lordships have seen that, my lord. How strongly the court has put it, my lord. Then, my lord, is your lordship's order, after noticing the entire proceedings, etc., issuing show cause notice to him as to why the bail should not be cancelled. That your lordship's order is of 20th of November 2025.
Just
After which,
one, मैम आप एक काम करिएगा, ये minus
I will do that, my lord. I know, I've seen, my lord. So I'll put it in a bunch, my lord, and with an index. I'll give an index and.
No, only without the.
No, not the relevant, all orders.
Only date,
All order.
date and order.
Without the appearances.
Without the appearance. And
Date
the bench
and
combination.
and bench combination.
And the bench component, the first page and the relevant term. The first page will have the bench component.
Prepare an index in a tabular form Excel sheet, the date of the order, the bench composition,
All right.
and the extract, not the extract, but the orders.
Gotcha.
Just a comparison.
We'll do that, my lord. We'll do that today itself. We'll do it, my lord. My lord, two more orders, 22nd April 25. 22nd April 2025. I know the appearances, my lord. 3-4 pages are taken because there are a large number of lawyers, my lord. The affected parties, my lord, there's so many allottees, my lord, or waiting, my lord, for 15 years. Yeah. Okay. 22nd April 2024.
Yes.
25. The lordship has it?
Yes.
The learned senior counsel appearing for the petitioner seeks time, that's Mr. Diwan, though more than sufficient time has been granted to enable the petitioner to comply with the condition on which he was enlarged on bail. Only by way of indulgence, we are granting time till next Tuesday, 29th April 25. This is how, my lord, strongly the court was, my lord, the court was very upset because despite, my lord, getting bail on the condition that he will settle with all the investors, my lord, 5 years down the line, nothing, my lord, had happened. And I will show, my lord, my learned friend's averment and assertion that, my lord, he settled with 53. My lord, they are only paper settlement mediation agreements. I will show that because he has not complied with that. So he enters into these settlement agreements and he doesn't comply with them.
Those parties with whom we had entered into settlement,
Yeah.
are they before us?
I'm preparing for that. I will show from my application, I filed those settlement agreements. I filed those settlement agreements to show this is what he promised me and he doesn't fulfill that promise.
Ma'am, we'll have, just note down, if you will stand up, then everyone would stand up. We'll give you time, we've told you.
So, my lord, I'm appearing for some of them, my lord. My friend also appears for other allottees, my lord. We filed the settlement, my lord. He says, I will do this. And then we sign it.
Now show that.
Yes, I'll show that. My lord, just one more order, 29th of April. 29th April 2025. So court wanted to see that the project is, court was trying to ensure, my lord, that the investors and the unit holders get possession of the property. April, may I read, my lord?
Yes.
Firstly, we'll deal with the issue of settlement entered into by the original petitioner with 41 buyers of the units whose names appear in Annexure 820 to the affidavit. It is claimed in the affidavit, possession of 23 units has been handed over to the persons mentioned in Annexure 820. It is stated 10 purchasers whose names appear so and so have shown unwillingness to take possession apprehending that registration of the document will not take place, we direct UPSIDC to immediately nominate 3 senior officers to visit the building in which the units mentioned in Section 820 are situated. Officers will visit the site when a representative of the petitioner shall remain present, along with all documents such as occupation, CC agreements, if any, entered into with 41%. Representative of the petitioner will also bring the document showing delivery of possession as regards these 41 units, excluding the units to be allotted to 8 persons who have allegedly taken refund. The officers of the authority shall verify the documents produced by the petitioner and submit a report to this court on the following aspects: whether the units mentioned at serial 1 to 23 and units mentioned at serial 1 to 10 are in habitable condition. Because, my lord, there are 7 reports which are available on record, my lord, that they are not at all habitable. Whether there is electricity and water supply available to these tenements, whether there is occupation completion certificate with respect to these 33 units. My lord, now that the judgment in the other matter has given findings on this, finding that they are incomplete, there is no final CC, and my lord, they are completely, my lord, not habitable. That all those findings, and my lord, the court also record that settlements have not been complied with. I will show that also. From the judgment in IBC matter, that findings have come now against that. My friend should have read it, my lord. Whether there is an occupation CC, whether possession of these units has been handed over, my lord, if it was only bona fide effort, why was this court so concerned time and again trying to ensure that these unit holders get possession of the property? Then they should have left it at that. We have already passed the order. Now to make efforts. Is that so? No, my lord. The court's intent and object was very clear. We are granting you bail so that you hand over completed units to the investors. That was the object and intent with which bail was granted to this person, not with any other object. We make it clear officers so nominated by the authority will act as officers of this court and not officers of the authority. We'll permit the person's name appear so and so to remain present at the time of inspection. Authority will file an affidavit stating aforesaid fact. Will also make a statement whether it is in a position to execute tripartite agreement to which the petitioner, purchaser, and authority will be parties, and in what manner tripartite agreements will be executed. We also add that these officers will also ascertain whether other units in the building in which these units are situated are functional. The affidavit report shall be filed by the authority, which will be considered on the 7th May at top of the list. The authority to also indicate the amounts, if any, payable by the petitioner to the authority in respect of these 33 units. As regards the name, the petitioner shall file an affidavit. Court's order refers to dispute between the petitioner. We have dealt with 41 investors out of 103. We direct the petitioner to file an affidavit in relation to the remaining 62 about the progress made in the settlement. Affidavit shall be filed by 13. Learned counsel so and so stated to be allotted. She is willing to settle either so and so. So, my lord, a very detailed order is being passed by the court. And, my lord, not only this order, but orders from time to time. It is very clear, my lord. The court was, my lord, very conscious of the fact that these people, my lord, have paid their money in 2010-11. And, my lord, the units have not been either completed or handed over as per the allotment letter, my lord, and the agreement with the parties, my lord. With this backdrop, my lord, with this backdrop, your lordship then asked me the question about those settlement agreements. Would your lordship, my lord, I'll come to the judgment after, because your lordship wanted me to read the settlements. After I read this kind of settlements which were entered to do, which are not complied with, then I'll take your lordship to the judgment of this court.
Whichever way you,
yeah.
Whichever way.
Yes, my lord.
See, what is falling from the bench, you just note down, your colleague can note down.
Yes, yes.
And then you can respond in the manner in which you will.
I'll do that. I'll do that. Now, my lord, if your lordship has miscellaneous application 25807, that's filed by the allottees whom I represent, my lord, Surjit, Ford, and others. This is filed in 2024. 25. My lord, please.
25.
My lord, is 25. Is it 807? 8074. 258074.
This is IA filed
by Surjit Kaur and others, my lord.
allottees.
Some of the allottees, and this was filed in 2024.
No, this is these allottees are the ones with whom he had entered into settlement.
Yes. Precisely, my lord, precisely. And my lord, we refer to this court's order of 2nd September granting liberty to file, my lord, an application for cancellation if, my lord, there is a violation of the condition. Please see para 1 of my application. The present application is being filed in pursuance of order of 2nd September 24 by as per this court in the caption MA on behalf of the applicant's respondent number so-and-so on the status of final settlement. Please make a note because that's your question. On the status of final settlement, if any, done by the petitioner. Present applicant's respondents were included as respondents in MA 239 in the caption criminal writ petition and were directed to file the respective statement on affidavit as to whether petitioner has done the complete final settlement with them or not, a true copy of 2nd September order. Lord, please see para 3, that it has been more than 4 years. Please note, my lord, it has been more than 4 years since mediation. Part settlement agreements were executed by the petitioner with these applicants respondent, and there has been no final settlement ever done by the petitioner with the applicants till date. Petitioner has violated all terms and conditions laid down explicitly in the said agreement. So he enters into the agreement, he doesn't do anything. That the falsehood of the petitioner is not only limited to his false claim of providing full settlement, but right from project inception, wherein petitioner has committed various illegal and fraudulent acts. Now see para 5A. Projected a rosy picture of the project by luring the applicants to invest in premium office space. My lord, the brochures are very nice to see, my lord. And my lord, he gave a commitment of assured returns of 12% till final. Roman 2 at foot of the page. Petitioner provided commitment of assured returns at 12% till final offer. Then, my lord, about the project we mentioned. Then, my lord, please see point B at foot of para 4. Fraudulent agreements executed with respondent by another company. No, my lord, the lease, my lord, this is very important. Just make a note of this. The lease by the UPSID is with Bhasin Infotech, not with Grand Venetia. So what he does is, obviously it's a sister concern where he is interested, and that's the corporate debtor 2 in that matter, my lord. There were 2 corporate debtor, Bhasin Infotech and Grand Venetia. So he sets up this company and makes it a marketing agent according to the agreement, which we pointed out in the other matter. This company then enters into agreement with unit holders on the assumption that, my lord, that Grand Venetia is a lessee from UPSID, because UPSID files an affidavit in this court to say, we don't recognize Grand Venetia, we have given you lease agreement or lease deed in favor of Bhasin Infotech. So, my lord, we were made to enter into agreements with Grand Venetia when Grand Venetia itself had no authority. Please see point B. Fraudulent agreements executed with the respondent by another company without any rights granted by UPSIDA. Subsequently, on 14/12/2009, petitioner without prior information to UPSIDA transferred development rights of the units of the respondent to another company, Grand Venetia Commercial Towers Limited. That this was via an unregistered and unnotarized JDA and without any kind of leasing rights granted ever by UPSIDA. This was a clear violation of lease deed clause 3J for the said project, which says lessee will not, without the previous consent in writing the lessor, transfer, sublet, relinquish, mortgage or sign its interest in the demised premises. We have, my lord, annexed that agreement also. And my lord, UPSIDA has come on record, filed an affidavit that they don't recognize this company at all. They don't recognize, they said we have given lease to Bhasin. How will tripartite agreements ever be executed? Because UPSID does not recognize this company. And this company has entered into several agreements with unit holders. See Roman 2. This company started executing allotment letters for office said unit with all the respondents in it, without any authority, my lord, and taking money from us. Default by petitioner in providing possession. As per the commitments made in the allotment letter executed in 2011-13, there was possession to be offered within 18 to 24 months.
No, Mr. Mehta.
Sorry.
See, on this point B, we are now examining a position, his conduct rather.
Lodge, please. Lodge.
Post 6th of November 2000.
Correct. My lord is right.
No, your ground B here.
Yes.
Is prior there too.
But it will have a bearing. I'm going to answer your lordship's question. It will have a bearing on the fact that, my lord, unless, apart from the fact that the unit is not completed, which is what UPSID is placed on record, can tripartite lease deeds be executed with this company with which is not a lessee?
Point is,
yeah,
we are now into cancellation.
Correct. Violation of condition. One of the condition was you will settle.
Correct.
So can they settle? That's my question.
Makes attempts to settle.
But Lord, later orders made it very clear the object was you will settle with them. You will give them possession and execute tripartite. That's what the order, subsequent orders say. But Lord, that is the purpose of my reading the subsequent orders.
Can we change the tone of the settlement order to make it more strict? Can the earlier terms of the order be made more stricter by subsequent order?
Lord, can I answer that? I'm so grateful for the question. My Lord, it is not even his understanding, which is very clear because he was actually satisfying the court by saying, yes, I'm doing it. He did not make, my Lord, any application to say, why are you asking me? I had to only make sincere efforts. This will amount to diluting or modifying the condition of grant of bail. No such application is moved. In fact, he understands that the court's order to mean that he has to settle. His own understanding is that. That's why I read all these orders. He never, my lord, squeaked or made any, my lord, submission that why are you insisting? I'm only making efforts, but these people are not coming forward or XYZ reasons as to why settlement is not taking place. Okay. That's not his understanding.
Just let's view it differently. After 6th of November 2019, where is the agreement of settlement which he has entered into?
That is what I'm showing. I'll show that, my lord. Immediately, my lord, your lordship will find 2019, your lordships have seen. That's the order. Now, please see page 198. I'm going to show one by one. Obviously. In this application, which your lordship has. I was going to read it from my affidavit, but since your lordship want documents, let me show the documents.
No, why we say so?
I agree.
Because you took us to ground B in your...
I follow.
Only from that point of view.
Correct. Now, my lord, so he was asked to settle. Now, see, this is 198. This is before the magistrate before whom this criminal case was going on. Please have 198 of this application, my lord. Your lordship has 198, my lord? Yeah, this is an order passed by the court. Jagdeep Singh is husband of the co-complainant in the above FIR, which was registered against the respondent accused in respect of booking of commercial office space in the name of Surjit Kaur and Mukesh Kaur. There was an office space measuring so and so. The co-complainant is paid a sum of 30 lakhs as part payment of the total sale. Booked space could not be allegedly handed over in time to the complainant. Agreed thereof, he got FIR registered. Parties have been able to resolve all their disputes and differences of the following terms. So it's being recorded by the court, my lord. Please turn over the page 199. So serial number 1, the respondent accused builder has offered to allot a commercial space bearing unit so and so to the allottee co-complainant in lieu of commercial space. So he gives some other space now. In lieu of commercial space initially allotted to him in the said commercial tower, company is paying so and so white check as an excess payment against refund for settling the case. 3. The respondent accused undertakes to register the aforementioned property before the sub-registrar within 3 months from today, and the charges for registration will be paid by the company and thereafter by the customer within 15 days. Also, this is to be assured by customer in order to register. Customer will come to the registrar office. that the builder undertakes to hand over possession of the above property to the complainant within a period of 30 days from today, subject to execution of required documents in this respect, complainant will not be charged a single penny, etc., etc. Now, my lord, he doesn't comply. Please make a note, my lord. This is after the order of this court. This is 29th of January 2020. Correct, my lord? Now see 202.
You write a letter to him.
I write. You have not done anything.
Then what happened?
Nothing. That's the problem.
That's what he's saying. He's trying. He's making an endeavor.
My lord, endeavor. My lord, your lordship is right. This endeavor then should fructify. You can't say I will enter into agreement and then say, that's all. It was only meant to be a paper agreement, nothing more. I was not required to actually implement the agreement. Can this be countenance? The court did not mean just simply entering into settlement agreement. Court meant you settle, you complete, and you hand over possession. You don't do that. Complete, execute tripart lease deed, and hand over possession. So I make a grievance on 13th April 2021 that you have not implemented it.
Is there any condition here in this settlement which requires approval of any other authority, UPSA or any other? Because that's what it was stated. I made all my attempts. Some other third party, some other conditions.
No, my lord, that's only the tripartite lease deed. I'll tell you, I'll explain to that, my lord. This is very important, my lord. I'm glad your lordship have asked me this question. My lord, it's one of the lease conditions. My lord, lease original owner is UPSIDA, the authority, my lord. It has given this land on lease, a long-term lease. One of the conditions in the allotment letter and the lease deed executed in favor of Bhasin Infotech is that when you develop the property, are entering into, my lord, agreements with the unit holder, it has to be a tripartite lease deed. Because the lessor is UPSIDC. It has to be, that's part and parcel of his allotment, his lease deed. And UPSIDC has filed affidavits, which I'll show to your lordship in this court, in these proceedings as well. So, my lord, your lordship have seen 202. Now I'll give you another example, my lord. Please see page 212. This is another agreement on 13th March 2020 with Dr. Sanjeev Khattar by Bhasin Infotech.
This letter of 202, does it give any response?
No, my lord.
That because of this reason I am unable to.
There's nothing on record. Please see 212 now. I'm just giving by way of illustration. I've given all the details and I've annexed all the documents. 212, 13th March 2020. So it's after the order. Yes, within 6 months. So he's making an effort to enter into agreements, but not implement the agreements. Yeah, that is actually overreaching. My friend, Mr. Arora is absolutely right. That's actually overreaching the order of this court. Please see 214. Para 3. Para 3. It is agreed that the second party shall have all rights in the units and privilege to use and occupy the unit. First party shall also abide by all terms stated in the allotment, further finish the work, obligations are pending as set out in the allotment letter within a maximum period of 45 days from the date of the agreement. Well, till date is not done because that finding has now come in the other order. I'm going to show that. So he was required to finish and then hand over. Then see para 6. As per the first party does not require permission of UPSIDC for subleasing of any built-up portion of the said project. However, the second party insists that a tripartite sublease deed executed with UPSIDC as a party in order to satisfy the second party that no permission of UPSID is required to such sublease the built-up portion. The first party is in the process of seeking clarification of the aforesaid. Pending the same, parties agreed that a sublease deed be executed only once the clarification, because he said, I will execute bipartite lease deed, not tripartite. So I said, how is it possible? He said, all right, I'll get a clarification from the authority. Authority said, nothing doing. No, my lord. So this is also not implemented. He has not, my lord, handed over possession or executed the tripartite lease deed. Then come to another agreement, just by way of illustration, 221. This is with Charu, this is Charu Saxena. 13th March 2020, same day as the previous one. I'm so sorry. I'm sorry. I have to take your lordship back, my lord, to 215.
Buyback.
Apart from, yes, my lord. Or otherwise, refund the money.
Buyback.
Yes, yes. That's right. That's para 11. So he has never offered this, my lord. Para 11.
You have seen.
Yeah. So the point I'm making is this, my lord. When you, my lord, give it a solemn, it's a solemn assurance to your lordship, my lord. It's a solemn assurance to your lordship. You can't, my lord, overreach and then take the court for a ride. You can't say I will enter into agreement, but I will not do anything. Then, my lord, the next one is 221, which is with Mrs. Charu Saxena. And, my lord, your lordship will find 223, para 3, 6, and 7. Same thing, my lord. That if he is not able to finish the work, enter into tripartite agreement, he will refund the money within 45 days with interest. And I was willing to accept 6%, my lord, at that point in time, because we were so desperate to get out of the project. We were so troubled. Our plight, my lord, has to be seen. And
15 months.
Correct.
He's not selected.
So, my lord, he's never offered this. He has not complied with it. And, my lord, I don't want to repeat, my lord. Your lordship can take it. There are, all of them have filed these such agreements, and I've given a table. I won't read it. If you come back to my application, I've prepared a table, my lord, at page 9 and 10. It gives all the, my lord, necessary details of each one of them and about the mediation agreements and settlements. And, my lord, the fact that nothing has been done. That's page 9 and 10 of my application, my lord. Page 9 and 10 of my application.
In terms of the agreement, did either of the parties approach the High Court for quashing the FIR?
For quashing? No, he had to approach.
No. See, one of the terms of the...
That first order your lordship is referring.
For compounding. For compounding,
yes.
Because one of the agreements,
yes.
Say...
I understand what your lordship is saying. I don't think that has happened, my lord. I don't think that is
200 for non-compoundable offences. It has been mutually agreed that the parties shall approach the High Court for caution.
No, I don't think.
So none of.
I confirm, but according to my instructions, nothing. But I will still confirm. I'll still confirm.
Happened was something different. If I can explain to my lords. My lords, when the matter came here, all those FIRs stood clubbed together, and the court said the lead one will go.
Now, we just want to know.
He got a stay, I think that 354, he got a stay from Allahabad High Court, 353. And all the other FIRs which had been clubbed with it never progressed.
1 minute.
No, but today charge sheets have been filed.
Yes, but you see what happened.
No, but today...
Charge sheet, he got a stay
today,
with the High Court.
Today, what is the status? What is the position with regard to the
investigation? He got a stay in the first charge sheet.
No, today.
No, they have not progressed at all. In some, even the investigation has been stayed. And my lord, what is significant is the allegation in some of those cases is 467, 468, which is.
But Mr. Sanghi yesterday showed us that
charge sheet is there. 3, I will show that. There not only 420, 406, 467, 468, 502, 504, all are there.
See, now we just want to know.
We'll give that.
Whether investigation has been stayed or not.
Some of them investigation has been stayed. In a whole bunch of them, in the whole group of them, investigation has been stayed.
See, then what you will have to indicate, tell us the figures, in terms of figures. How many FIRs are registered? What is the status in terms of investigation complete, investigation stayed, challan presented, and then 482 filed, and further proceedings.
State is not party here. State. Look, state would be actually in a better position to give all the
small sequence and enclose those relevant orders.
The reason is this: if we call the state, the matter would be still delayed. State of UPs are here.
Yes, should be a party to the state of UP should be a party here.
Yes, your lordship. I am present here, your lordship.
They are a party, my lord.
Yes, your lordship. I am present. I am here.
Is present.
Yes, your lordship. According to my instructions, your lordship. Yes, your lordship.
Come to the court. Come immediately.
I will come, your lordship, I will just come in 5 minutes, I'll just come.
Come to the court.
Yeah. Because I think he's the best person to inform your lordship about.
Come here immediately.
Just coming in.
We are rather requesting, our apologies. Our apologies to you, we request you to come here.
No, you come over now.
Yes.
It will take 5 minutes because the additional building.
Proceed.
That's okay, we are in 5 minutes, it doesn't matter. Yeah, I'm not done yet.
Yes, please.
So, my lord, I showed your lordship the table at page 9 and 10, each individual facts, my lord. And the fact, my lord, we have said that he has not done it. I said so on affidavit at page 12.
When did you file this IA?
This is 2024, my lord.
No, date.
Date. Lord, I filed it, I'll just give the date, my lord. Just give me a minute. This is in October 2024.
October 24.
Yes. 25th October. And my lord, page 12, sorry, my lord. Page 12.
Page 12.
Of the same application, because your lordship asked me a question, has he done anything pursuant to the mediation settlements? I am saying that he has not done it. Page 12. This is para F, my lord, at page 12, Roman I. That these commitments were, however, again violated by the petitioner, wherein he could not provide completion of pending work within 45 days, also could not get the sublease deed executed within 15 months, as the laid down in clause 3 and 6 respectively. Petitioner did not even comply with clause 7 of these agreements, wherein supposed to refund the amount with delayed penalty at rupees 10,000 per month, so and so. Even as on date, petitioner has got no locus to offer possession with mandatory tripartite lease deed, as the unit towers are incomplete. There is no final CC and various NOCs are still pending. Lord, I think this is the opportune time, Lord, for me to read the judgment of this court, Lord. Because this judgment of this court has given recorded findings on all these aspects. It will save time. Please have a judgment of this court, Lord. This is Satinder Singh Bhasin versus Colonel Gautam Malik and others. Is this, Lord, I think Mr. Devan had already given it, but I'll give more copies, my Lord. Just give. You have 2 copies? Yeah.
This is the keeping all the proceedings in abeyance. Judgments this are tagged,
I see.
Supreme Court clubbed them by its order.
So, my lord, this allottees had moved, my lord, an application before NCLT, my lord, under IBC Code, Section 7. That was admitted, my lord. Because, my lord, 2 things are to be seen in IBC matter, my lord, Section 7. Whether there is a debt owed and whether there is a default. NCLT found that yes, money was taken and, my lord, project not completed, nor possession handed over, so there is default. Petition admitted by NCLT, NCLAT dismisses it, matter comes to this court, and my friends, my lord, Mr. Devan argued this matter, and my lord, please see some of the findings recorded by the court in this. Same issues, my lord. Please see para 15 for a minute. I don't want to read the entire order, my lord. The lordship may see it later, but I'll read a few paragraphs.
You will not see anything later. Please, whatever you have to say, you say just.
All right, para 15. No, I understand. Para 15, your lordship has it. Significantly of this order. Significantly.
Just 1 minute.
Sorry.
Yes.
Significantly, the allotment letter dated 5th August issued in favor of Bhasin by UPSIDA apropos the lease of the subject land specifically mentioned that tripartite lease deed of the built-up premises had to be executed by UPSIDA with the ultimate allottees of the developer on the request of the developer in writing. Therein, such allottees were to be shown as lessees, and UPSIDA would transfer the proportionate undivided interest in the land, while the developer would transfer the interest in the built-up space. It was categorically mentioned in the allotment letter that lease deed of the built-up space would be executed only after issuance of a completion certificate for the built-up space. NCLAT noted that admitted position was no tripart lease deed was executed since 2006, even for a single allottee. Then, my lord, para 17. In this regard, NCLAT also referred to the joint venture agreement dated 1412 between Basin and Grand Venetia, which I said, my lord, is not the lessee. Therein it was stated UPSID had allotted land in favor of Basin. Basin was constructing a commercial shopping complex. Basin desired to grant exclusive marketing rights for the purpose of selling units in the commercial complex. Grand Venetia approached Basin and expressed his willingness and consent to do so. Basin granted exclusive marketing rights for selling the commercial units constructed by it, and Grand Venetia was authorized to receive and collect payments on behalf of Basin only as its agent. Thus, according to NCLAT Lady showed, both companies were involved in the project and could not claim to be independent of each other in relation thereto. NCLAT also noted, though delivery or possession of the units was to be made within 5 years from the date of allotment, the same had not taken place till date, as no tripartite sublease deeds had been executed. Pausing here for a minute, my lord, I must point out the CRP application is 2021. This is not prior. This is subsequent. These proceedings in IBC are initiated on an application filed in 2021 after the 19 order granting bail. This is not prior. This is later. The initiation of proceeding under IBC. I'll give the date, Lord, of initiation of proceedings. 7 July 2021. So it's much later. No, initiation meaning filing of the application. 7 July is the filing of the application by the allottees under section 7 of IBC code. Para 18. So 6th line I was reading. NCLAT opined construction had not been completed. Please make a note, my lord. NCLAT, this is the 7th line in para 18. NCLAT opined construction had not been completed and found assured returns were admittedly not paid to the allottees since 2014. Reference in that regard was made to the letter addressed to the allottees by Grand Venetia, stating that possession of the units would be delivered shortly as structures were nearing completion. But due to recent slowdown of the real estate market, revenue generated was needed and therefore difficulty was being faced in paying the monthly returns to the allottee. It was proposed that in lieu of the monthly returns for the balance period up to the date of handing over, extra space would be after adjusting the balance amount. Then please see 19. The NCLAT also took note of the status report dated 11 September 24 filed by RP appointed by NCLT on admission of the company petition, which reflected construction of the project was incomplete. Report reflected that the units from 3rd floor to the 8th floor were bare shell structures with raw concrete and debris scattered all around, and even basic elements such as doors were missing. It was further recorded therein, no construction had taken place from 9th floor to the 15th floor. The reference was also made to NCLAT appointed observer's report dated 15th May 2025 and UPSID's report dated 1/5/25, which affirmed the findings of the IRP, concluding that construction was not complete even as on date of the order. NCLAT dismissed the appeals filed by the directors of both the corporate debtors. The core question raised before us, then my lord, the other side raises a preliminary objection on that eligibility. There had to be 100 allottees. Now, my lord, para 21. However, as noted by NCLT, no documentary evidence was produced before it in proof of settlements having been arrived at with any of the allottees, showing that the petitioners in the company petition prior to the filing, that is about 2021, in any event, day of reckoning has to be taken. That's the legal argument, my lord. So no settlements, no proof was filed. Then your lordship may come to, my lord, page para 25. Para 25. Because today, my lord, my friend wants to disown and, my lord, say that he has nothing to do with Grand Venetia. Because, my lord, the other allegation is about siphoning of funds. Now, please see para 25. As regards the contention, joint company petition could not have been filed for initiation of insolvency against two separate companies. We may note that letter of allotment in relation to the lease land was issued by UPSIDA on 5th August 06 in favor of Basin alone. The project was therefore to be undertaken essentially by Basin. It was only thereafter that 14/12/09, Basin enters into an agreement with Grand Venetia, granting it marketing rights in relation to the sale of the units. It's a matter of record that two companies had common directors, including Basin, for some length of time. And my lord, now he's filed an affidavit to say I have nothing to do with Grand Venetia. Because, my lord, the IRP has filed an affidavit about siphoning, my lord, after the order granting bail of 74 crores. 74 crores. And he's saying I have nothing to do with Grand Venetia.
You'll have to show this document.
Yes, yes.
Just make a note and show that.
Yes, yes, of course. Further, demand notices and possession letters were issued by Basin to the allottees of Grand Venetia, and correspondent communication with the allottees were by both the companies interchangeably. So even Grand Venetia is holding itself out as if it has a lease from UPSIDA and entering into agreements with these unit holders and taking money from them. Payment receipts manifested. Then, my lord, in reply before NCLT, we find Grand Venetia stated it was highly reputed marketeer. This claim stands decimated by the fact that Grand Venetia was incorporated and came into existence only in November 09, barely a month earlier. It therefore had no reputation or experience as a marketeer, so to speak of, and appears to be incorporated only for the purpose of entering into an agreement with Basin in relation to the subject property. Before, the appellants have stated Grand Venetia purchased 1,114 units in the project on so and so for 218 crores. There is thus no possibility at this stage for either company to say they are not jointly liable to the allottees of the project. The NCLT and NCLAT were therefore justified in concluding that the corporate debtor were intrinsically linked and that would be in their interest to have a joint insolvency process so as to maximize asset realization. Now come to 28 below, para 28. We may now turn to the claim of the appellants. That is Basin, Satyendra Basin. We may now turn to the claim of the para 28 below. We may now.
Para 27, last 4 lines also.
Yes. The argument that these two companies were independent therefore falls to the ground. I'm so grateful, my lord. I seem to have missed that. My lord is right. They were jointly answerable to the allottees. The filing of simple company petition again was not justified. Now come to 28. We may now turn to the claim of the appellant that construction was complete and units were ready for occupation before the date of filing of the company petition. According to UPSIDA, which had allotted land to Basin for erecting the project, construction was to be put up within 5 years from date of allotment, which is long past. Project had to be put up on the allotted land was a single project comprising a mall up to 3rd floor, commercial spaces from 3rd to 15, and a hotel in the adjacent structure. As per clause 3P of the lease deeds, Basin was required to construct the buildings on the leased land within 60 calendar months from the dates on which lease deeds were executed or such extended period of time as was allowed by UPSIDA in writing. UPSIDA asserts delay in completion of the project and execution of tripartite sublease deed is attributable to the corporate debtors. The UPSID claims corporate debtors committed default in payment of its outstanding dues and had not even furnished to it the final list of allottees. This is very important, my lord. Because, my lord, he does not even furnish the list of allottees to the authority, that unless the authority has list, how will, my lord, these agreements be entered into? It further stated it was never called upon to execute tripartite lease deed. On the other hand, civil suit was filed by Basin challenging the clause in the lease deed which stipulates such tripartite lease deeds have to be executed. The suit is stated to be pending. The list of allottees was communicated to the UPSIDA for the first time under letter dated so and so, but it was full of discrepancies. My lord doesn't even give correct list, and the final undisputed list of allottees is yet to be shared with it. This was stated to be sine qua non for execution of lease deed, tripartite lease deed. It was stated project does not have a final CC for entire construction, and the hotel part of the project was not complete. UPSIDA asserted part CC was not for the whole project. According to it, affidavit dated so and so was filed in the suit, stating that part completion certificate were ineffective as the conditions stipulated therein were not complied with. The UPSIDA further stated its dues of 54 crore were payable by Basin. Writ petition filed by Basin in that regard was dismissed by Allahabad High Court on 8 September, granting liberty to UPSIDA to approach the IRP to lodge its claim In this regard, we may note, my lord, then the building regulation which points, my lord, that you have to have a final CC. It doesn't have a final CC till date. Now see para 31. Handing over, taking over possession letters issued by Basin in favor of allottees recording delivery or possession of particular units have been placed on record. However, we find some of those letters pertain to first floor of the building with which the petitioning allottees in the company petition have no concern. Those letters do not further the case of the appellant. A letter was issued in relation to the unit on the 7th floor in favor of Sheetal Badwar, but the undertaking of the allotee record sublease deed with the UPS ID was yet to be executed. Further, notional possession letters were also issued to allottees, which is of no significance whatsoever. These so-called letters of actual delivery of physical possession, in our considered opinion, have no legal import, given the categorical stipulation by UPSIDA in its allotment letter and also the lease deed that physical possession should not be delivered without execution of tripartite lease deed. And it doesn't give the list of allottees to the authority. So when can it be, my lord, these deeds be, my lord, entered into, and when will possession will be given? God knows, my lord, 15 years down the line. Para 32. Though the appellants have also placed reliance on part completion, part occupancy, and earlier coupled with the notional physical delivery of possession, same have to be construed and understood in the context of the extant legal regime and contractual clauses. The clause in the allotment letter and clause in the lease deed of CPS makes it clear that possession would not have been offered to allottees without tripartite lease deeds being executed. So what is this settlement, my lord? This was clarified by regional manager of UPSID in his letter of 21st February addressed to one of the allottees under RTI. He confirmed therein no tripartite sublease had been executed in favor of any allottee till date. And in the event the builders have executed sublease deed directly in favor of any allottee, the same would be in clear violation of terms and conditions of allotment letter and the lease deed. We may note some of the letters issued in 2015 by Basin mainly offered notional possession to the allottees. Letter dated addressed to Kamaljeet Singh, one such allottee, is placed on record in this regard. Part completion, part occupancy, and notional physical possession delivery letters issued to the allottees, therefore, can be taken to be proof of completion of construction now as being claimed. It was being claimed that this is sufficient. The court rejects it. Further, their claim in that regard is also belied by the Commissioner's report dated 17th May 18, filed before the High Court Delhi in an earlier winding up proceeding. Therefore, the Commissioner has recorded none of the units were ready and fit for occupation as on the date of his inspection. Report formed part of the record before NCLAT. Though we would ordinarily have restricted the scope of inquiry with regard to documents prior to the date of admission of company petition, which form part of the record before NCLT, we may note that the appellant secured an interim order from NCLAT on 7/12/23 by claiming that construction was complete and that units were ready to occupy. The interim order continued to operate for nearly 2 years thereafter. It was during the pendency of proceeding, NCLAT undertook the exercise of verifying this claim of the appellants and appointed an observer to visit the premises and submit a report as to the situation actually obtaining. It was pursuant thereto that the observer's report came to be filed before the NCLAT, leading to dismissal of the appeals. We are therefore of the opinion this report also warrants examination. And look at what the report says, para 35. Look at what the report says. In this report dated 15th May 2025, para 35, the observer stated he had visited the subject premises on 10th May, accompanied by representatives of the suspended management of the corporate debtors, the financial creditors, and UPSIDA. With regard to units on 9th, 10th, 11th, 12th, and 14th floors, the observer noted only 1 out of 6 lifts. 1 out of 6 lifts in the office building was working, but the lift also had accessibility only till the 9th floor. So it did not even have accessibility above 9th floor. On that floor, observer found no units had been constructed and was told by the representatives of the suspended management that no units had been constructed on the 9th floor and above till the terrace, that is 15th floor. As regards units on the other floors, observer noted that upon reaching the 8th floor, he found that the said floor was partly constructed but lacked basic amenities such as bathroom, lighting, air conditioning. No fire safety equipment was installed on the said floor. Similar was the situation with 5th, 6th, and 7th floor. On the 4th floor, observer found unit walls were made of gypsum-like material and not brick.
was telling my lord that of late we have stopped our morning walks or walks. So let us go to the unit and see if
Well, it'll be no pleasure, unfortunately.
Continue.
Lord Justice Deepak Gupta had to climb 15
Yeah,
floors.
that's what my lord.
That's what that's the report, my lord.
He read it.
No lift. And my friend says it's completed. I am ready to hand over possession.
Justice Rekha Palli, she told me that she couldn't possibly climb that much, so she stayed back. Justice Gupta being from the hills, Your Lordship.
Continue.
Again, basic amenities were missing. And observer opined, fifth line, that it would not be possible to hand over immediate possession to the allottees of the units on this floor. The units on the third floor were also found to be in the same condition, as some units did not have partition between them, and a lot of construction material was stored in one unit. He concluded that at present, commercial tower office building integrated with the mall was only partially built and lacked basic amenities. He further stated the units situated in all the floors required substantial amount of work to be done before giving possession to the allottees in a fit and proper state. Pictures appended to the observer's report in relation to third floor show there is no possibility of actual physical possession being delivered of any unit on the floor to the allottees. Viewed thus in totality, contention of the appellant that construction was completed in all respect and possession was delivered to some of the petitioning allottees is found to be without merit and factual foundation. So I don't know, my lord. My friend said everything is hunky-dory and everything is ready. Sorry, my lord.
You read this order.
You read the order. Very well, my lord.
What else? How much more time you take, Mr.
In that 20-25 minutes, half an hour, I don't know. So your lordship, I can do it tomorrow, my lord.
No, we are in no hurry. But what we just wanted to know how much time you take.
I can continue tomorrow also.
Would you be able to conclude today's what we have?
I can try, my lord. I can certainly make an attempt, but I don't know. I have something to add, more to share.
No. Take your time. We are just only wanting to know. हम 2 बजे बैठेंगे सर. Friday को आपको तो नहीं. Yeah, you continue for some time, 10 minutes, and then we'll continue tomorrow.
Very well.
Tomorrow 2 p.m. Mr. Mehta?
Yes.
Tomorrow 2 p.m.
Yes, sir. First.
For 10 minutes we'll continue, and then or you want to do it tomorrow? Tomorrow you take how much time now? Broadly.
I will try to finish it in 20-25 minutes. I'll try.
And then after you amongst you
my friends are all here, my lord.
No. We just, as we said, you choose who's going to be there after Mehta, so that we know and how much time you would take.
I think because it's Mr. Mehta, I think Ms. Arora should go for allottees.
Okay.
Then
after my friend is largely covering the field, and
what we'll do is
we'll be taking a short time.
No, what we'll do is that after Mr. Mehta, then Ms. Arora.
Yes.
So that the allottees are.
Yes, so you know I have one more suggestion, which is because your lordships were looking at that FIR, the 353, and you wanted some clarity on it. There's an IA we have filed in 25 called, it's 285421. If your lordship can just keep that aside, because that will help illustrate what's happened with 353. Effectively, that FIR was to be the lead FIR. All other charge sheets were to be filed as supplementary charge sheets in that. Now, very smartly, they went and filed a quashing of only 353, saying I'm settling with that allotee. So 353, contractor, settling with the contractor. Based on that statement, the court records that 353 is put in abeyance. As a result, despite your lordship's order consolidating everything, the entire matter has been frozen. So we needed clarity on that. That application deals with it.
You do one thing. By tomorrow, you just tell us on an Excel sheet the number of FIRs which have been registered, the status of each one of these FIRs. Each one, when we say each, means a number of petition, a number of FIRs which have been investigation stayed, A, investigation stayed, B, investigation complete, C, trial stayed.
I can just,
or-
now itself I can just.
give it in writing, give it in Excel sheet.
For a moment, I'll do it just for a moment.
With reference to the specific provisions,
Do that.
statutory provisions,
happened
penal
is-
codes.
Penal
What
code.
has happened is, your lordship, after consolidation order, your lordship, only 353 was made the lead FIR. The rest of the FIRs were treated as statements only as per my lord's judgment. So the 353 has now been stayed by the High Court. The trial is stayed as such, it is not progressing. After the consolidation, your lordship, 8 FIRs were registered, of which cognizance has also been taken on 5th of June 2025. But since the lead FIR is not progressing, your lordship,
Nothing is happening.
nothing is happening.
That 27th April 23 High Court order should have been brought before your lordship.
What is the reason for stay?
Because that initial FIR, the lead FIR, was with the contractor. The High Court records there, it is a matter where accounting is to be settled between the parties for certain materials supplied and rent to be given. This is the exclusive nature of dispute. That being the case, obviously no one appears despite service of notice upon private respondent informant. And as a consequence, till the next date of listing, further proceeding of case so-and-so, arising out of case so-and-so, shall be kept in abeyance.
This is not the unit holders.
No, this is not unit holders. But because we are all stuck in a train behind this lead FIR goes into abeyance, everything goes into abeyance.
My lords, can I just clarify over there?
Just clarify one more thing.
Let me just clarify.
That clarification should have been sought by them on day one.
No, I will respond to
This is not
the
the moment to
interim
come and take a
application.
clarification.
No, he's moved an interim application, and I must disabuse this notion that we had not disclosed it before the Honorable High Court about the pendency of other FIRs. So in total, there are 41 FIRs insofar as Grand Menace project is concerned. My learned colleague had stood up and said that there are 190 FIRs. There are no 190 FIRs. It is mentioned, specifically reflected in the consolidation order that there are 41 FIRs insofar as Grand Menace project is concerned. Incidentally, what had happened was that there were 2 orders passed on the very same day.
Yes, I
One was with respect to Grand Menace project, and another was with respect to a scheme called Bike Bot scheme, in which rightly or wrongly the petitioner got implicated because the principal accused in that case had invested some money in this project. So by virtue of indirect insinuation against him that you also may have been part of the conspiracy, he was also arrested in that case.
That's a pity.
Subsequently, this honorable court not only granted him bail and protected him for future FIRs, but consolidated even close to 94 FIRs with respect to Bike Bot scheme. Insofar as Grand Menace is concerned, the parent FIR is 353, where the person concerned happens to be a vendor as well as an allottee. Now, the question which was specifically put to us was, which is the first FIR which was registered first in point of time? That was 353.
No, we just, sorry for interrupting.
Yes.
Disturbing your
Yes.
Without intending to distract or disturb.
No, yeah, absolutely. I'll be very forthright.
What we wanted to know.
Yes.
That you have the information. There are how many FIRs registered against
Yes,
you?
ma'am.
You both sit and you.
Yes, no, I will put it on
1 minute.
Yeah, I'm so sorry.
You sit with them tonight.
Yes.
And collate
Yes.
the data and give it to us in authentic.
Absolutely,
form.
there's no difference.
When you say Grand Venice means Grand Venice company or the entire
Project. The judge order says project.
What we are saying is.
Yes, ma'am.
What we intend to say is this, that when we are talking about FIR registered against you.
Yes, ma'am.
It has to be either against Mr. Basin,
Yes.
who's before us, or the company, but it has to be in relation to the entire project.
Yes.
Yes, ma'am.
See, the hotel, the mall, and the other, whatever you have bifurcated. Please.
I got you. And I'll just take 30 seconds more. Insofar as the investigation part is concerned, pursuant to the orders of this honorable court, a composite charge sheet came to be filed in
23rd December 2022.
23rd December 2022. The court took cognizance not against the offences which were flagged up by my learned colleague yesterday, 467, etc. Because police, after conducting a detailed investigation.
So the investigation, the cognizance is only in relation.
My lords, insofar as Satyendra Basin is concerned, even with respect to the second supplementary charge sheet which has been filed, the cognizance has been taken only against 406. That's part of an IA which I have moved, placed on record the relevant orders.
Yes, Your Lordship. I have to.
And even insofar as the details with regard to these 41 FIRs are concerned, there is an order of November of 2023 where the Advocate General for State of UP stood up, made a mention about the other FIRs before Honorable High Court. Despite that, Honorable High Court said, considering the civil dispute, the nature of the dispute being civil, we intend to stay the proceedings, and that is where we stand as on date. Yes, and there is an ancillary issue also that one of the complainants, she moved an interim application with respect to that stay, which was declined by this honorable court by a bench headed by Honorable Mr. Justice M.M. Sundaresh and yes, this is where we stand.
I have to just inform. I just have to inform your lordship the supplementary charge sheet is filed in the 420, 406, 123 IPC, as well as the different charge sheets under.
Yeah, you give it to us tomorrow.
Yes, we'll place it.
Cognizance has been taken under
Or you sit down, work it out.
Yes, sir.
We in fact,
taken under
just to
406
answer Justice Singh, we have it in our IA. There are 46 FIRs with the provisions of law, 41 in UP and 5 in Delhi.
1 minute. Nikali do zara. Aye.
Which IA number?
The total now 54
Copy of the IA.
54 FIRs.
Take minute.
Diary number 276.
May I be excused then in case I have to continue? Grateful.
What's that?
May I request?
We'll stop the hearing now.
Very.
We'll say tomorrow.
Tomorrow. Grateful. अच्छा चलो. No.
There are 54 FIRs.
एक मिनट जरा वो आइए देख ही लेते हैं.
Give it up. Of 26.
That's right. Yes, that's right. Ganesh?
ये जरा ऐसे ही दे दीजिए, दिखा दीजिए. $41 in UP and 5 in Delhi.
Total 54 FIRs. So 8 were registered subsequently also.
Subsequent. This is
What does EOW mean?
No, economic offences during Delhi, and these of FIRs also stood merged and amalgamated. And firstly, they were transferred to state of UP because an SID was constituted by a 3-member bench of this honorable court, and which in fact consolidated the matter. And then the matter was thoroughly and detailed investigation was conducted. So Delhi FIR also got merged with the UP FIR, which is the parent FIR. In fact, because the principal contention of most of these aggrieved parties was that UP suits us better. Majority of the FIRs had been registered.
There are 4 benches of this court dealing with different aspects of the same judgment.
We can't say anything about that.
Yes.
May I request for a copy of the IUS?
Yes, yes. Just give.
Bilal, ये note.
Profit.
We have heard Shri Rubneta for some time. List tomorrow at 2 p.m. for further submissions.
May I just request, my lordship said us to prepare the chart, my lordship. Now, since there are only consolidated FIR is there, my lordship supplementary charge sheet, do we have to prepare for the different FIRs?
Yeah, absolutely.
Individual FIR.
FIR.
Where, right? Individual FIR.
I will do that.
And the stage where, see, why should the High Court stay the
So what has happened in this, after the consolidation, my lordship said that the rest of the FIR will be taken under a statement under 161. They were not to be considered as
because
that is the order of the 12th of May 2022. That's why I asked.
But that order was ex parte.
No. That was not actually.
No, the High Court order.
Investigation
High Court order was
as far as we are concerned, your lordship, and the cognizance has also been taken under 406 and 120 the IPC.
Why have you moved an application for disposal of that matter pending there in
High Court, your lordship. I have to take instructions on that.
Just take up that whether you have moved any application.
We'll
obviously he won't do that. You have to do that.
We'll take instructions because I'm also told, I just heard also that since one of the authorities had come before my lords and the SLP was also dismissed, I'm not aware what has happened on behalf of the state. So I was asking the separate FIRs we have to prepare on.
We don't know.
Consider as statements.
At this point in time, you are in the middle. I don't know whether you're here or there.
I'm always on their side only. I will be always with the.
Tomorrow at 2 p.m.
Very
Thank you.
Yes,
This, we are very clear that we'll request my lord and honorable the CJI that it will be on day-to-day basis. We are very clear about it.
Yes, great.
With no question.